Paragraph 13, no? Operative part.
So you file it during course of the day.
Yes, Your Lordship, within the course of the day.
You are for the writ petitioner.
Yes,
in all
Your
the three
Lordship.
matters.
Yes, Your Lordship.
All the three matters. That in compliance of the court's last order.
By my senior, Mr. Vikramaditya Ghosh. He is engaged in court number 5, my lords. He has several matters pending there, my lord. Let it be fixed on Monday.
Monday, next week, day after tomorrow?
You are seeking adjournment before a division bench because he is appearing before a single judge bench.
There were several matters, my lord. Kindly appreciate it. Monday, my lord.
Unique prayer you are making.
Pardon.
Unique prayer you are making that we should adjourn the matter because the learned counsel is busy before a single bench.
Kindly.
Give the file.
Hmm?
You don't know what to say and what not to say. We don't know who has sent you to make such a prayer. Okay.
He's on his
Ask
legs.
you, you insist on the prayer.
Sorry.
You will hold up the division bench because the learned advocate is busy before a single bench.
Kindly, my lord. Innocuous play, my lord.
Let's see what it is. You start, he'll come. You know, appreciate a simplistic prayer for adjournment. You're saying it's easy before a single bench.
Yes.
Therefore, which the division bench
Yes.
should adjourn. the matter. Wonderful things you are teaching.
No, my lord. Kindly allow.
No, what is it? Let us see. taking so casually in court.
No, no, my lord. Thank you.
The way.
No. Yes, my lord, appeal has been preferred challenging the order of the Honorable Single Judge, whereby the writ petition was disposed of, granting liberty to the petitioner to prefer an appeal before uh, before the statutory authority under the Customs Act against the purported sanctioned order, my lords, whereby the interest which we had prayed for initially in the writ petition was not granted, my lords, in the sanction order. They simply prayed for that interest also be disbursed along with the sanction amount.
Okay. That's what I ordered. That's it. Yes.
You ask a junior to seek an adjournment because we are preparing before a single bench.
That was already called up. It was on legs, that's why we led.
What is wrong with the order?
I was only praying if you lordships take it on next Monday, kindly.
Why? What is there?
But
The
I have
issue is
to-
decided by the court. The court said go to the statutory authorities. You went to the statutory authorities, you got the amount, you want some more. Now at this juncture, the court will jump in again, but it is to be considered by them. in
No,
their-
Millet, my only respectful submission
Yeah,
was,
see, the earlier bench which took up the matter did not say he will not get interest.
Yes,
Did not
yes,
say he will
190.
get interest. So it is all left to them to decide. So well, the question.
no,
of
Millet,
how-
I was only on the point, Millet, that instead of relegating me back again before the appellate authority, it was, Millet, the reed court was competent enough, Millet, I am equipped with some of the judgments also to grant me the interest. Because, why I am saying this, Millet, an appeal,
Then what will remain in 128?
Millet, as has been desired by the honorable single judge, that I prefer an appeal. But the question of
No,
appeal,
as is the desire of the statute.
desire of the statute,
Yes.
but when section 129 will only come into play, Millet, in my limited understanding, when there is an adjudication on merits, when there is a proceeding within the meaning of the Customs Act. Here, if your lordships kindly consider the facts and circumstances of the case, the honorable division bench only
According to
directed,
you, the original remedy is correct, but the appellate remedy is without jurisdiction.
no, I am saying, Millet, for an appeal, there has to be a original order.
What is this order?
The order that has been passed by them in granting me the money, though it is styled as an order in original, but it is mere a communication of compliance of the honorable division bench
Provision
direction.
Such an order is passed.
Kindly, Millet, if Millet kindly takes the Customs Act once.
Justice.
But I have,
আমি আনতে পাঠালাম।
but I have only one copy, if your lordship looks at it.
Central and all states there are 15. Please read.
Yes. Let 128 is the first provision under chapter 15 which deals with appeals. Marginal note, appeals to commissioner in bracket appeals. Subsection 1, any person aggrieved by any decision or order passed under this act, by an officer of customs lower in rank than a principal commissioner of customs or commissioner of customs may appeal to the commissioner appeals within 60 days from the date of the communication to him of such decision or order. Then the
Any order.
proviso,
Any order.
any order under the act.
So if at all, anybody could be aggrieved by the order of the honorable single judge, it would be the customs department. How can you send us before us when we have no jurisdiction?
No, kindly see the context in which this order was passed.
We have seen, that's why we are asking.
Millet, this order,
See, there is a perishable item which has been seized.
yes,
When it has perished, you said, I will not take it, you give me the money.
Yes.
They give you an assessed amount, whatever it may be, XYZ. You are not satisfied with the amount. So
no, Millet, I am not, it was never my case that I am not satisfied with the
that
amount.
appears to be because that is for that purpose, it was relegated.
No, no,
And you
no.
went there and you got the amount.
Millet, kindly, Millet, let me, Millet,
Where is the earlier order?
Will it-
Pursuant to which you went before the authority?
I never went before the authority. There was no proceeding under the Customs Act.
Then how did you get
Millet,
that
the
amount?
honorable division bench of this court, Millet, in an appeal, Millet, kindly see what has happened. They have initiated a proceeding. They have confiscated my goods. I challenged that order, the proceedings of confiscation before the statutory authority, then the appellate authority. Subsequently, before the tribunal, CSTAT. CSTAT held against the department. They say that the entire proceeding is absolutely null and void. You have failed to establish any allegation of smuggling. That was subsequently upheld by the honorable division bench. Then honorable division bench says that since the goods are perished and cannot be returned at this point of time, you pay them the money back equivalent to the value of goods.
Where is that order? That's
Yes,
what we are asking.
yes,
My
yes.
lord, in page number 116. Division bench order is 108 and the relevant portion is 116. March 20.
It starts at 108. The relevant portion is at 116. Supreme Court orders.
Yes.
So, Millard, so far as the proceeding under the Act is concerned, against which, Millard, I have a remedy before the appellate tribunal, that chapter is already exhausted. Appellate authority has considered the case. Confiscation was held to be legal. The tribunal subsequently held it to be illegal, which, Millard, is upheld by the division bench. The only thing, the division bench directs me to make an application for refund of the money.
No. Please read again.
Yes, the application, if made, shall be dealt in accordance with law and disposed of. But at the last line, liberty.
Coming to the issue, read from now coming to the issue. Page 116.
Yes, now coming to the issue of return of the goods, admittedly, the goods are perishable in nature and the goods were seized on 1st March 2016. And the question of returning the goods to the respondent in Casta 22 of 2022 at this juncture does not arise, as the goods would be unfit for human consumption and it will be against the public interest to direct return of the goods. Therefore, to that extent, the order passed by the tribunal stands modified, giving liberty to the respondent
Giving
in
liberty to
the respondent, that is Millard,
or what?
the petitioner before your
For what?
lordship, namely so and so, to seek payment of the value of the
Value
goods.
the goods.
Value of the.
Yes,
That is what is left to the authority to decide. Not
Right.
to say you decided.
no, Millard, kindly, Millard, let me, Millard, allow me to finish it by making an application before the concerned authority.
Yes.
And if such application is made within a period of so and so days from the date of receipt of the server copy of the order, the said application shall be processed in accordance with law.
So who is the concerned authority according to you?
Millard, the concerned authority, we made an application.
Who is it?
Millard, kindly text my application, Millard.
What is the authority? Which
Millard, the Commissioner of Customs, Excise and Service Tax. Shiliguri Commissionerate. So, Millard, so far as valuation of the goods are concerned, there was no dispute whatsoever.
That was the only dispute remaining.
No, there was no dispute.
Finished.
There was no dispute. There was,
Because the value was never quantified by.
it
anyone.
was, Millard, it was. There was a seizure list. The seizure list in, under the Customs Act.
That is what was left open by the division.
Millard,
It said
subject
you
to
go for
correction, no.
ascertaining the value of money.
No, Millard, Millard, kindly seek the word seek for payment of the value of the goods.
Value of the money.
Value of the goods was
Yes.
never under
Not
dispute.
such and such amount.
Milord,
Would have said such and such amount.
Milord, the value was on the date of passing of this order, the
Yes.
value was already on record in the schedule list.
Yes.
I cannot go beyond that. Neither the authority has subsequently gone beyond that. It was paid to me. Now subsequently,
To get into this.
No, Milord, subsequently, we preferred an application before the same bench, seeking modification of this order to the extent of grant of interest.
Yes. Where is
This-
that order?
Milord, kindly take page 193. The last line, which Milord, according to me, paved by way to prefer a subsequent writ petition.
Post determination by the commissioner.
No, before I'm sorry, Milord, after determination of the commission. Kindly marks the date, Milord, subsequently.
What is the date of the commissioner's order?
Milord, the commissioner passed subsequently the order which Milord is looking at today regarding the valuation that was passed subsequently. Till this date, when this application was made, the order was not passed.
The date of the commissioner's. order.
Yes, Milord, I'll just place. Milord, kindly text Milord, 9th February 2026, page 197. And if Milord kindly sees the order, even on that day, the amount was already admitted and determined.
Nothing changed. Nothing changed by passing of the subsequent order.
Well, after the subsequent order, when the authority decided the amount, they reduced it to a certain extent. Because they had to go by the seizure list. We said according to the seizure list, whatever it is, disburse it. I mean, had there been a determination, even what Milord is hinting at, there has to be a proceeding according to the Customs Act. Where was that proceeding? No notice issued.
You have invoked their jurisdiction for the amount.
No, Milord, I have not. The division bench directed me to make an application and seek
And you
disbursement.
complied with it.
Yes, I complied. I made a simple application,
You
disburse
have
it.
invoked the jurisdiction.
I never, Milord, no. Milord, had I been invoked the jurisdiction, I would have invoked a provision of the act, challenging something within the meaning of the
Prior to
Customs
the
Act.
order passed by the division bench, you had taken up the matter up to the apex court.
Up to the apex court, they took it. Division
Whoever.
bench went
So
in
it
my
had
favor.
traveled up-
Yes,
traveled up to
that was in connection with the proceeding. After that,
the- This time, nobody took it beyond the division.
no.
You accepted it and you availed the remedy, you invoked the remedy.
Yes, I
That's
made,
what we are saying.
Milord, I am not invoked any remedy. I only said division bench gave me the liberty to make an application
Before
seeking authority,
concerned authority.
concerned
Who
authority.
is the concerned authority?
The concerned authority I have indicated before, Your Lordship, Milord, it is, yes.
Now,
So
let the reports.
Milord, I
jurisdiction
made an
to get into
application.
this,
Milord,
Whether what is the amount of interest to be.
Milord,
paid.
I made an application. They disbursed the amount. So, Milord, how this can be treated as a proceeding within the Customs Act against which an appeal will lie?
This is the only provision, there is no other.
Milord, there is no provision even.
Then
Confiscated
it
goods,
stands concluded according to you.
proceedings stood concluded on the day the division bench passed the order and subsequently
And
when the
how
SLP
do
was
you
admitted.
How do you circumscribe the jurisdiction under 128? Which word you are picking
Under
up to say that this cannot be?
Under the Act.
Yes.
Any decision or
Any
order,
decision
Milord,
or order
or order, it is qualified
by the lower. authority.
under the Act,
Yes.
under the Act.
So refund is not under the act.
No,
All right.
kindly seize the order, whether they have invoked any provision of the Act in granting me the amount.
What is the question of invoking any provision?
That's what exactly I'm saying.
There is.
If it is not invoked, Milord,
There is a seizure, there is a confiscation confiscation held to be illegal. The consequences have to follow under the act. Under the act, they are returning a particular amount. Under the act, you have an appellate forum. There is a question, there is no other place it can be done.
Milord,
There is no other place it can be done. It
Milord-
has to be before the
Milord, whether,
appellate authority under 128.
Milord, whether,
The appeal provision does not say only for adjudicatory proceedings. It says any direction or order.
any decision or
decision
order
or
under the act.
Yes.
So let kindly seize the order that they have passed.
Let's.
They have styled it as order in original. Kindly Milord seize the order. Order in original,
Page.
197.
We don't think there can be any other provision. There cannot, unless you show some other provision.
Like, according to me, it is pursuant to a direction by the division bench. And refund was Milord, a natural consequence,
So you
which
never challenge this order of 9 to 20.
I'm not challenging. I'm not challenging. I'm only saying you have disbursed this, and according to Milord, the latest
Now
judgments
the
of
writ court should determine the.
writ court should direct them to grant the interest in addition to this. That's all.
What is the final order?
Yes, Milord, it starts at page 198. Milord, if I may just, Milord, interject for a moment. At page 205. Discussion and findings.
And where is your application on which this order was passed?
Yes, that was certainly not under section 27.
Let us-
So I'll show. Milord, 177. There were several representation, Milord, this is one of them.
It is the basic representation. The
Yes, 177.
No, this is not the first.
Milord, the first was not available with the client, the subsequent representations was available with the client. Milord, I inquired this.
This is the first.
Milord, the first is not on record, Milord. It is not available
Not
with the
on
client
record, why
also.
you have withheld it from the record? That's what we are asking.
No, Milord, it was not available with him. He has misplaced it. The
Where have
subsequent,
you said in the petition that we are not annexing it because it was misplaced?
Milord, if I may say this, Milord, it must be part of their records if they may produce.
Why, sir?
Milord, they have
Why you
received
not
it.
produced?
Milord,
Why
they
you
have received
withheld
it.
this? Why you have suppressed this?
No, Milord, there's no
So
intention
from
to
the
suppress.
petition you are bona fide that you have stated why you have not.
Milord, that
annexed
may
it.
not have been stated, Milord, in clear terms, but that was not available.
Where is it? Shows that averment.
With para 7, we have stated that we have made the representations, but this is not available. That has not been specifically
So
available.
how do you know that it was not available?
Milord, I took instructions, I remember this.
Without an averment, you will make a submission. Very well.
But I am saying it is not available. It's not part of the records.
It is not annexed. That's why we are
Yes.
asking you why you have withheld this,
Milord,
suppressed
Milord, the
this.
second statement from
Most
your
relevant.
lordship, Milord, the second statement from your lordship that I have withheld it.
Yes,
Milord, there is nothing to suggest on record that I have withheld.
because your representation.
No, Milord, I have not. Milord, there's
Please.
nothing to suggest. Milord, let them produce. They have
See-
received a copy.
see, You come.
Have they,
to-
Milord, have they?
Come
Milord-
to page one eighty.
No, Milord, have they ever made out a case
Come to.
that I
page
have
180
intentionally withheld that with a purpose?
Come to page 181. You are expected to come with all facts and clear clarity when you approach a writ court. This is not the way. These are settled principles.
Milord,
of law.
over 4 years, at least 6 to 7 representations were made. Milord, it is very much possible, Milord,
You know
that a
very-
litigant might
Sir,
lose
you-
one of those copies.
no, litigant may lose, litigant may say also.
May
Now-
say, may
now-
not say
now
also,
you
Milord,
know-
does that,
you
Milord,
know-
does that, Milord, raises an adverse inference that I've withheld it?
Why? See, because
There's nothing to suggest that.
our observation.
It is not the case of the department.
We are here, we are looking at the records.
Milord, kindly seize the subsequent representations. I have referred to that.
Just calm down, just calm down. Because you said it was certainly not under section 27,
Yes,
very loudly.
yes,
So
Milord.
we said, let us see what you have filed it under. Now
Yes.
it is not there.
Milord,
Now that's a relevant fact. You know it's a relevant fact.
Milord, had it
Because you
been,
made a submission that is not under 27.
Milord, had it been
Then
under
why you have
section,
suppressed that?
Milord,
Then we asked you why you have suppressed it.
Milord, had it been under section 27, had
We
it
will
been
not
under
go by
section,
presumptions and we will not
Milord,
allow you to
sec-
make submissions on presumptions. It
Milord,
will be as per
section-
the pleading.
section
It will
27,
have to be as per the
section
averment.
27, just because, Milord, an officer has mechanically recorded section 27,
Therefore,
Milord, where is the question, Milord, I asked this to
See-
myself, where is the question of claim of refund or duty? Is it a case?
that
Under
is-
section
that
20,
will
for an
come-
application to be
that
made under
will-
section
That
27?
will come later. The first thing is what you have styled it. You said we have certainly not under 27.
Milord, whatever representations are there,
You see,
none of them
Sir,
are
please-
styled under
please-
section
Please
27.
come to page 182,
Yes,
paragraph 2, made an application.
yes.
We are saying, where is that application?
Milord, I informed your lordship, the first application is not available with the client. He has misplaced it, that has
You
not
can
been
say
averred.
that, You can say that, but your client has chosen to suppress this fact.
Milord, I come back with a supplementary affidavit stating
Yes.
this statement on oath.
No, why? Now, at this stage, after the.
Milord,
writ court
how
is
that initial representation is relevant today?
over. That is because you submitted it, it's certainly not under 27. Therefore, you
yeah.
know how it is relevant. You
Milord,
know how it is.
I
relevant.
don't have a document.
We don't have to tell you how it is.
Milord, I don't have a document. They, throughout the writ proceeding and before this honorable court, they have never said that they have not received any representation.
No, it is
Milord,
referred to.
Milord, allow them, Milord, direct them, request them, Milord, to produce a copy of it. Matter ends.
It was
Anyway,
not the
so
issue.
which other provision it is under? You tell us.
There is no provision. That's the first, Milord, since the last half an hour, Milord, this is the only respectful submission.
Let
And
us see.
kindly seize the order, the
So
second
the-
line.
The return of a confiscated good is made under which provision?
No, there's no provision under the act. The court directed, they are requested, they are under obligation to consider my application. Even if there was no direction from the division bench, it was a natural consequence. If your proceedings are found to be bad in law, you can either return the perishable goods or value equivalent to money.
So there is no procedure in the.
There is no procedure.
So once, according to you, if we accept what you are submitting, once a good is confiscated, whether it results into a finding against the person or not, it will not be returned.
No, if Millard, ultimately the confiscation proceeding is
So
set aside.
therefore, it has to be returned as a consequence of the order passed.
Order passed.
Correct.
Order
That's the
passed.
only way it can be returned.
Right.
In no other way.
Absolutely.
So
That
therefore, it is
order-
a consequence of the order which is appealable.
That order has been carried into appeal
Yes.
before the tribunal,
So
all
now
statutory
by-
remedies exhausted.
By breaking it up in parts, it will become a subject to the writ jurisdiction.
Look, I am not breaking it in parts. Millard, kindly see the second, the next paragraph of the order,
Yes.
order in original,
Yes,
4.2 at page 207.
yes.
This order is passed in compliance with the directions of the honorable courts and in accordance with the provisions of law.
Where are you reading?
Millard, 4.2, 207. And Millard kindly also takes the background of this. When the writ petition was filed, the Honorable Single Judge directed them to come up with a compliance report. Once that direction was passed, they came up with this order in original saying that we have passed an order in accordance with the act. It was nothing, Millard, but a compliance of the direction of the division bench.
You may say so, sir. But ultimately, it is as a consequence of an order passed by the authority. It is not an adjudication by the writ court.
Right.
Yes.
So
It
if
is a
that is so,
consequence of the order passed under the statute which and
If-
orders, it is as a
Well, if-
consequence of the orders passed which are appealable.
Millard, if that is so, the order should look like one which has been passed as a consequence of a proceeding under
Yes,
the
by
act.
now, we need not impress upon you that non-mentioning of a provision will not invalidate the order. It is see,
Well, it
that's
is-
why we have repeatedly been asking you. No power, no authority has a power which is not granted to it under any provision. Every power has to be channelized. The power of refund arises as a consequence or return of the goods would only be as a consequence of an order passed in a adjudicating proceeding. It cannot be otherwise.
Right. In this case,
Now,
Millard,
in this case also, the return of goods is as a consequence of an order passed in an adjudicatory proceeding. You say, I will not accept the goods because it is no good. Court says, all right, instead of goods, you take them. So that will make it another order. Wonderful.
exactly that's what I'm saying.
That's-
That there cannot,
That we have understood
there
what you are
cannot
saying.
be, there cannot be two orders under the
We
act.
have understood what you are saying.
There cannot be two orders under the act. Millard is absolutely
So
right.
where are the two orders?
If we treat this as an order, there are two orders.
There is only one order.
There is no, that order was affirmed by the division bench. The entire proceedings culminated there. Matter is over.
Therefore, that order, the consequence of the order.
Now they cannot again start a
Where is that
proceeding.
order?
Millard,
You are trying to start a proceeding.
No, I am not start. I am only saying you have granted me the money back. Kindly grant me the interest also.
That's what we are saying. You are trying to.
Well, how there can be two orders in original?
Where are
Rightly
the-
observed by your
where are
lordship.
the two orders.
This order, if I am said by this court that now you prefer an appeal in accordance with section 128, that means there are two orders in original. One order you have passed that I have tested up to the Supreme Court. Now, so far as interest, there can be another order in original.
And in which, under which provision the adjudicatory order is passed?
Their original adjudication order. I'll just show.
Just show the provision.
Yes. No. Provision.
Possibly
We want to know the provision.
116.
116.
There are several penal provisions. Millard, I was just trying to ascertain which provision they have invoked here.
ওটা নাই বইটা লাগে ফার্স্ট অফিস দুইটা নিয়ে আসবে এটা বইটা সঙ্গে ধারা এখানে
They had invoked 111B.
Why, that's why we are saying, how you are saying 116?
111B is what they have invoked. 116 million is also the penal provision, but my confiscation and imposition of penalty was done under 111B.
Judgment का तो सेट है. Set.
গাড়িতে ছিল confiscation. Yes, 111. ওটা কথা রিভিউটা রিভিউটা কথা বলছি।
इसके कॉपी निकल
May I, my lord?
Millard, our Supreme Court, Millard, has dealt with similar circumstances. CGAT's order was challenged, where it was held that the interception of the goods was illegal. The court said, in spite of alternative remedies in torts, court can award Millard interest, 12% interest
Who
was
is saying
awarded.
the discretion is lost?
Yes. Millard,
Nobody is saying that the
My-
writ court's discretion is lost.
my case today is that a
The issue is
person,
that when the writ court has seen it once,
Millard,
then before or short circuiting the alternative remedy, whether you should be allowed to come again. Maybe after the appellate authority, you may come, we don't know. That has not been shut off.
Millard,
You insist that at this stage you must do. The writ court.
my case is
No,
today.
that is the
My
issue,
case is today,
whether
Millard,
there is an enforceable
there-
claim at this stage or not.
There-
That's the only issue.
Millard, their order, which they have
Nobody is
passed,
saying that the discretion is lost and nobody can say so.
Millard, the order that they have passed.
Order that they have passed,
It-
now we are seeing the provisions. Now it
yes.
is clear.
So there is no provision under which this order is
You
passed.
can say so, you may say so.
It
we'll
was
see.
from the order
You
itself.
will see, you may
Millard-
say so,
Millard,
we'll
from-
consider
from
what you are saying.
From the order itself, Millard, subject to correction. Your lordships may have noted that the entire order takes a color as if it is a compliance of the order of the honorable division. Save and
We don't
except.
know that
Millard, what,
colour- that
Millard,
colour-
what characterizes the order?
That color has not been placed before us. We'll ask them to place that
Millard,
also.
What characterizes the order? The order characterization of an order, Millard, is an element of
Those are issues
adjudication.
which come much later. At the moment, what is the issue is whether the writ court has rightly refused to exercise jurisdiction because there is an adjudicatory forum available. That's the only issue.
App-
Everything comes after that.
Appellate forum.
Yes,
appellate
everything
forum.
comes after that.
Millard, I am only saying, this is, Millard, just a compliance as directed by the division bench.
Even so,
And that is not an appealable order.
even so.
Millard, that is not an appealable
That
order.
you have already said sufficient number of times. Yes,
May I, my lord?
yes.
My lord, division bench on 14/3/23 has already passed the order. 14/3/23,
Where is their application? Bring it by Monday. Bring that application.
which application? my lord?
The application, original application filed after the court's order.
Acha.
Then we'll pass the order.
But this, in the subsequent application, they have,
Bring the original application, sir. They have not placed it, they have, so you bring it.
moreover, regarding interest point has already been
Yes.
decided by the division bench.
Take down. We find from the records that the writ petitioner has annexed copies of representations made as a follow-up to an original application filed pursuant to the order dated 14/3/23 passed by the division bench. This is evident from fair perusal of paragraph 2 of the representation dated 31/5/23. So the original application referred to in paragraph 2 of the representation, however, has not been placed on record by the writ petitioner. We therefore direct the respondent custom authorities to place the same before the court when the matter is taken up on.
Next.
Come in the next week. Great.
application dated 24th March.
24th March.
24th March 23.
It is there.
No, it is subsequent application will be there.
So bring that 24th. Thursday.
kindly fix it Monday. Because the.
Thursday next, sir.
Next Thursday.
We have given you sufficient time, ample time.
This month. April, 16th April.
List it at 2 p.m.
2 p.m.
Grateful.
Item number 21.
Lordship, praying for not today, Lordship.
It's
22.
defective. You have not even removed the defect.
Lordship, praying for not today. I'm not aware of this.
Not-
Item 22. 23.
Where is? Give 22. Where is 20?
And for item number 23,
Item 22. Meta theory. Puzzles কবি দিয়ে দিই তাও লেখেনি কি নামে আছে
Amijul Mia.
None appears for the appellant.
Well, it is number 21, my lord.
It's 22.
Is it serial number 21?
Advocate for the respondent.
22.
The matter is adjourned Wednesday, day after.
Well, 8.
Item number 23.
Your Lordship,
CGST.
Your Lordship, I'm for the appellate in item number 23.
Yes.
I'm praying for not today, Your Lordship, as the arguing counsel is coming from Bangalore. So I'm praying for a one-day accommodation, Your Lordship.
Not today.
My lord, kindly fix it day after tomorrow.
Not today.
Much obliged.
24.
Lord, I'm for the state.
None appears. Same order. Thanks.
Item 25,
My lord, 25, I beg to appear for the respondent number 1 virtually, my lord.
last order though. Last order, sir.
पहला वाला कौन सा? लेकिन
অর্ডারটা বের করো না মানে অর্ডার হয়েছে
in terms of the last order, my lord, Mr. Chaudhary was supposed to, my lord, come back with a report probably.
লাস্ট অর্ডারটা
Who is appearing?
My lord, there was a my lord, the 18th March 2026, my lord. Pursuant to that, I have informed to the court that already SIT has, my lord, constituted. And my lord, to some extent, the difficulties is that after the, my lord, the MCC invoked, my lord, the members of the through the ECI, my lord, Election Commission of India, the members of the SIT, the IG has constituted, IG North Bengal, the Commissioner of Police, Siliguri Police Commissionerate, and the SPs of 2-3 districts, my lord, and the additional SPs and the DCP. My lord, again, thereafter, after their transfer, my lord, the person who has incumbent in these positions, my lord, have taken over this position, my lord. And then, my lord, preliminary inquiry, my lord, we have conducted because the allegation was that in the, my lord, the BLLR office, the Rajganj office within district of Jalpaiguri, there was a missing file of 5,000 mutation cases.
5,000?
Mutation cases, my lord. My lord, the land records cases, my lord, in where the mutation certificates were granted. That was the, my lord, the preliminary report submitted by the, my lord, a special team constituted for this purpose initially, my lord. Then thereafter, what happened, my lord? The SIT was formulated. My lord, may I hand over the preliminary report?
Why, who is this gentleman, the writ petitioner, why he is here?
No, my lord,
Writ petition.
along with this
My lord,
appeal,
writ petitioner is the respondent, my lord.
my lord, we, in the original writ petition, my lord, the allegations, when the writ petition
You
initially,
are not for the writ petitioner.
no, my lord, I'll just tell your lordship, writ petitioner came up before this honorable single judge saying that with regard to mutation, there are rampant corruption, kindly look into it. And he portrayed as if I have, in one of the mutation cases, I am the person or we are the persons who have orchestrated a fraud on the office and have done, my lord,
Alleging that you are a beneficiary.
beneficiary of a fraudulent mutation. Now, we intended to add ourselves as a party in the writ petition because the private respondent here did not originally make us a party. We made an application for addition of the parties. Now, my lord, the writ petition was disposed of finally without allowing that application for addition. Now, in course of the writ petition, when the writ petition was heard, my lord, initially the honorable single judge directed an SIT to be constituted by the superintendent of police. That committee was constituted, investigation was carried out, charge sheet was submitted against all of us. All the appellants in these two appeals, item 24, 25. Charge sheet was submitted, investigation ended. Now, when the writ petition came up for final hearing, that earlier order of Justice Sinha, the honorable single judge who constituted the earlier 3-member team to investigate, that fact was entirely suppressed before the honorable single judge. And the honorable single judge was probably, my lord,
What was the relief claimed in the second?
My lord.
there was no second writ petition. In the continuation of the writ
After the
petition,
report, it went back.
no. The honorable single judge directed constitution of a team
Yes, SIT.
headed by the superintendent of
SIT
police.
is a
No, my
team,
lord.
knowledge,
Team. The SP was required to investigate.
with the land department's officer.
We're constituting a team. He investigated, he constituted the team. Proceeding FIR was lodged, charge sheet submitted against all of us. Then the writ petition was kept pending for a prolonged period of time.
All right.
It was kept pending for a prolonged period of time. When the writ petition came up for final hearing, the state's compliance report, although it came, it was not highlighted before the court that this exercise the state has already conducted. The private respondent as the writ petitioner in my absence, without adding me as a party, although my application for implement was pending, my counsel was not present. He, Millard, I won't use the term, the Honorable Single Judge passed an order, again, Millard, directing the Inspector General to constitute a team and do the same exercise again.
Where is that order?
Millard, the impugned order, that is Millard with the memorandum of appeal. Now, Millard, since we were not added as parties in the writ petition, and Millard, we are aggrieved by the second exercise of investigation, we came up before the Honorable Division Bench, and Millard, along with this appeal, we have preferred a leave to appeal also. The leave to appeal, Millard, is yet to be allowed.
The last order's compliance statements ensure that in the.
Last order is 18th March.
Yes.
Yes.
No,
And then
18th
13th February, Millard, they have sought to file an application with the leave and the condemnation of a delay. That is Millard pending.
Whatever it is, first you comply with this order.
Millard, we have complied. That's for this reason. I have a preliminary report. Millard, that's I have intended to Millard hand over. Millard, the annexers are here, Millard. It's only I'm just handed over the reports, Millard. This is voluminous the documents, Millard. I am equipped with this. Unless the court, it is for the consumption for me. I shall look up later. These are the Millard, the members of the SIT, Millard.
So second FIR was also registered.
Yes, Millard. Initially there were 3 affairs, Millard, which ended with the charge sheet. Then we have prayed before the jurisdictional court for Millard of further investigation. That prayer was allowed. Those 3 affairs. Millard, the second page, Millard, kindly see the C in my report, which is addressed to me. which I have handed over just.
When the entire matter is in season of the criminal court, why this court should be pursuing the matter?
No, my lord. Actually, what happened, that 3 affairs particularly for the individual mutation cases. And then thereafter, when the
See, there are some complainants who say that our land records have been, somehow it has been manipulated. They say the BLL, RO and the head clerk together with the beneficiaries have done this.
yes,
The original documents are gone and fresh documents have been
yes,
put in place.
yes.
This is the ultimate conclusion till now. Earlier, they had approached the court, there was a direction, proceeding had started. Later, they came to say that since the document is not there, it is not recovered, I may be faced with a problem in future.
True, my lord.
So therefore, now the court has embarked upon trying to trace the documents.
No, my lord. Just may I interrupt,
Yes.
my lord? My lord, initially, when with pertaining to the my lord, read petitioners and the others, my lords, the respondents even, they are the complaints.
Whatever it is.
Maybe X, maybe X.
Yes.
The complaints were that forged document anyway.
It's not a PIL.
It's not a PL. my lord.
Exactly.
Then, my lord, the
Therefore,
Exactly.
no, my lord, then, my lord, a team has been constituted by the my lord, the honorable court's order.
That's good.
Team found there are the 5,000 missing. In addition to this, my lord, 3-4 my lord, the mutation cases, there are 5,000 missing records pertaining to the records of rights. Then, my lord, this honorable single judge, my lord, directed my lord, the Inspector General of Police, North Bengal, to constitute a SIT for investigation of the 5,000 missing files and how such on the basis of the missing files that mutation certificate was granted. That was the second round of exercise, my lord. Now, when this second round of exercise has been undertaken, my lord,
How can this be examined by a police authority? Missing records can be an issue,
my
but
lord,
anything beyond that is cannot be.
And
looked
there
into
was,
by-
Milord,
no, my lord,
not
the-
police
this
authority.
case
Milord,
was never
that's-
made out in the
Missing
writ
authority.
petition.
I understand. This is the reason, my lord, in the SIT, my lord, the land department, district magistrate, my lord, the ADM, LR, they were implemented in the SIT, my lord. So that to find out the, my lord, these missing records and as well as the persons involved in obtaining such mutation cases, my lord.
So at whose instance?
That it may be at the instance of the person's beneficiaries or at the person, definitely the office was involved.
Therefore,
But very
we are-
candid, my lord, without the,
Therefore, we are saying it's not a PIL.
no.
So at whose instance? Who is aggrieved by these missing 5,000 files that?
Exactly. That's
this
what, Milord,
entire
we have.
thing has
My lord,
We
my
are
lord, may I,
also
may I
saying
make
this in
submissions,
our
my lord?
opinion.
My lord, I am for the writ petitioner, my lord. My lord, what appellant has portrayed is,
Who are
my
you?
lord, is the ink. My lord, I am for the writ petitioners, my lord.
Huh.
My lord, what appellant is trying to portray here is completely wrong, my lord. This is not the events that had happened nor what has taken place, my lord. My lord, what has happened?
What
my
is
lord,
the
it is-
relief you prayed for in the writ petition?
My
Yes.
lord,
What is the
Yes.
relief you prayed for in the writ petition?
my lord,
Show
kindly
us, where
takes-
is the
yes.
relief?
My lord, in
Which
my writ
page?
petition, my lord, the prayers,
Please
my
show
lord,
us,
they have,
which page?
my lord, kindly takes the, my lord, I need to, my lord, there are voluminous documents, my lord. If this matter can be taken up tomorrow, I'll be
Please
physically
show us.
present.
Huh?
My lord, tomorrow I'll be
Then be
physically present,
physically
my lord.
present. Yes, come
My lord,
tomorrow.
kindly fixes
Hmm?
it tomorrow,
Not
my lord.
today. Yes, come tomorrow.
Deeply,
We'll
deeply
take this
obliged.
tomorrow. Please keep it with
25
you.
and 26, my lord.
Yes.
So, my lord, I will take back the report.
We'll take it tomorrow.
It's grateful.
It may be something we don't know. It may be something very.
My lord,
big.
I
But
understand.
why
Yes, my
the
lord.
writ court is to get into these.
Is exercising this jurisdiction, my lord.
The court-
Treating this repetition as a, my lord, PI. True. Because a larger scales, my lord, this can be, my lord, identified or can be taken into.
Now that everything is put in motion, they will proceed with whatever they want.
Yes, my lord. So, my lord, so this is the reason, my lord,
That is
pursuant
the
to.
prima facie.
Examine the writ.
I say things so that, yes.
But I will also request for Dr. Milord, this will take some time.
What is something?
Item 26. My lord, this
Same,
is
my lord.
similar matter. Deeply obliged, my lord.
Oh, mining.
27.
Tomorrow it will appear, there will be a note, not today, it will not be.
The NT late. 28.
Praying for not today.
Sir, everybody wants to.
The advocate indica due to his personal difficulty, he is not come, your lordship.
So tomorrow can be day after tomorrow.
Item 29.
Please, my lords, I beg to appear, my lords, for the appellant. My lords, this is a fresh matter coming up before your lordship. My lords, the impugned order, my lords, is in my favor, but my lords, I am aggrieved only by a limited portion. My lords, on the quantum of interest that the learned single judge is granted. I'm sorry, your lordship.
Milord, I am for the respondent, Milord. The copy of this appeal, Milord, has been served in our headquarters in Faridabad. Milord, I am yet to receive the copy. Milord, either they can serve me a hard copy today, or Milord, kindly, if Milord takes it up.
My lords, we served it to my lords. I'm sorry, my
Yes,
lords.
sir, you have any extra copy which he
My
can
lords,
take from you?
my colleague is there, my lords, she'll hand over a copy.
That's a copy.
My lords, a
Then
short
what you
issue
want?
on.
Not to.
Milord, takes it up on Monday, Milord.
As your lordship pleases.
Any day, any day.
Yeah, after Monday.
Any day, subject to Lordship's convenience.
A copy of the appeal is being served on the learned advocate representing the respondent. He prays the matter be listed on Friday, give the date of Friday. The list
Lords, I
accordingly.
have some difficulty on Friday, my lords. Any date except 9th and 10th, my lords, as your lordship pleases. Next week, any date, my lords?
Thursday, next Thursday.
Yes, grateful, my lords. I am grateful.
That's all right with you.
Grateful, my lords.
Item number 30.
Lordships, I am for the appellant. Lordship, I am praying for
Lordship, I am
1 day
for-
accommodation, your
I
lordship.
will respond. Lordship, Senior Advocate Mr. Amlish Roy is appearing in this matter. Lordship, my instruction is to take next week
No,
for the.
Lordship, the matter. Lordship, this matter filed by the Union of India. Matter filed by the Union of India, MES, Ministry of Engineering Services, your lordships. This is the intra-court appeal, your lordships. Honorable single judge pass an interim order, your lordships. We have against the interim order, we have preferred this appeal.
Mr. Roy will appear. on-
With the leave of the court, your
Next
lordships,
week,
without filing the certified copies, and subsequently we have already filed. So 1 day accommodation, lordships, kindly allow us to tomorrow, your lordship, place the case.
Mr. Roy will be available on next week.
Sir, online করে নেন।
Next week. There is no arbitration clause.
No, your lordships. The agreement, that is another fact. Fact is that, your lordships, the writ petitioner is enlisted with us as a contractor. Now the
The
CBI,
enlistment of, their enlistment as contractor
lordship, as a contractor.
It always
Under the-
presupposes that there will be disputes in future, so their enlistment does not come with a rider.
This is not for any particular contract agreement, your lordships. This,
We
this,
have understood what you are saying. This is a very common way of doing business, having a list of people enlisted.
yes,
and paneled.
yes,
Very
subsequently,
common, yes,
subsequently, we have received the input from the CBI.
yes.
CBI registered the case against the writ petitioners and others for corruption charges, your lordship, along with our some officers. Now, after the receiving from the inputs from the CBI, now your lordship,
Where is the suspension order? Where is the suspension?
suspension. Lordship, we can place the tomorrow, your lordship. Tomorrow.
What did the honorable single judge do?
Lordship, on that time, the matter circuit bench is not session. The principal bench, honorable single judge, pass an order without it, maybe the sub to the department or not, but our council
it
is
is
not present, your
mentioned in
lordship,
the
on that day.
order sheet. Mentioned in the order sheet that.
Yes,
Sub is
that's why, your lordship, the order passed expertly, your lordship, only the basis of the submission made by the writ
What is
petitioner.
the date of this order? This is for 6
Six.
weeks only.
Yes,
Actually, subsequently.
and subsequently, we have,
It has been extended for 3 weeks from 20.
subsequently, we have filed this writ petition with the leave of the court. Now, without filing the certified copy, so record is with the principal bench. As and when we receive the certified copy, we have filed, and first day, your lordship, it is listed, your lordship.
This is a writ petition.
Appeal, your lordship. Intercourt appeal. your
File a
lordship.
writ, you are saying file a writ petition.
No, appeal, your lordship. Suspension of 1 year, your lordship, 1 year business. I place the case, your lordship, tomorrow. yeah. Learned DSJ also.
Special Senior Advocate Mr. HON'BLE Roy will appear on next week. So kindly fix it matter on next week. So for the CBI case is concerned, last 2 years, no charge sheet has been submitted yet.
Yes, how much time do you want?
Lordship, next week.
Lordship, 1 day, as because your lordship, the writ petition already, as in when we have filed the applications, it was defective. Now, honorable, earlier honorable division bench, your lordship, call for the record, the writ petition. The writ petition was listed. Then and then we have filed our affidavit in opposition. Learned senior
No,
of the
affidavit
writ
opposition
petitioner
filed
pressed for
beyond
time.
date, Lordship.
Now 2 days fixed for appeal, your lordship. So lordship, matter is urgent and sir, lordship sensitive. Lordship, 1 day accommodation, we place our case, then your lordship make this.
Come tomorrow.
Lordship, grateful, your lordship.
Ask him to appear, I can appear online. Some urgency.
Lordship, then it kindly make it
Grateful,
day after tomorrow. Lordship.
All right, day after tomorrow. Tomorrow with not today.
Lordship, day after.
Day after.
Item number 31.
Please, Milords. Milords, 31 and 32 are connected, Milords. There is, Milords, a question of law which arises for your Lordship's consideration, Milords, which is whether a second writ petition is maintainable, Milords, seeking review and recall of an order passed in an earlier writ petition. Your Lordship will kindly see the impugned order for a moment. In item 31, Milords, this is of 9th January 2026.
So what has been decided by the order?
So, Milords, I had filed two separate writ petitions. One of the writ petition has been dismissed on the ground that the petition is not maintainable. In the other one, Milords, learned same single judge, Milords, declined interim relief and passed a prima facie observation that the learned single judge feels that it is not maintainable. So, Milords, I have come in appeal in both. And Milords, the issue before your lordship today is a pure question of law, Milords. On whether, Milords, the writ petition that I had filed was maintainable or not.
But both these orders are passed in the same WPA.
Your lordship is having WPA 2576 of 2025.
Yes.
So that's item 31, Milords. In this case, interim declined, and your lordship will see there is an observation that this is not maintainable. Prima facie.
Yes.
And Milords will now
Yes.
see 32, Milords, kindly for a moment. Item 32, the impugned order, same single judge. That one, Milords, has been dismissed. So ultimately, Milords, both Milords, I had to file an appeal so that your lordship could decide the question of law.
Why did you file two writ petitions?
Milords, because there were two orders passed by the single judge, Milords, in
What
two
was the
different
order?
writ
What
petitions.
was the order?
So,
what
Milords,
was
what
the
had
order?
happened? Yes, Milords, the private respondent, Milords, filed a writ petition suppressing material facts, not making me party, Milords, and obtained orders from this honorable court, wherein, Milords, directions were passed to the BLLRO, saying that, Milords, their application alleging that certain false deeds have been submitted should be decided. But, Milords, my contention in the writ petition was simple, that I was a necessary party, one. Number two, Milords, there were prior proceedings which the private respondent did not disclose. Three, Milords, I was not made a party, Milords. Therefore, Milords, I had to file a separate writ petition seeking review and recall of those orders.
So then why did you file the second writ petition?
Milords, because there were two separate orders, Milords, passed by the learned single judge in the earlier round. That was, Milords, initiated by the private respondent. So I had filed two separate to recall, Milords, orders passed in those two separate petitions.
There were two separate proceedings.
Yes, Milords.
And in both the proceedings, it was regarding this land records only.
Yes, Milords, land records and Milords, same BLLRO, Rajganj.
Both the
Milords,
records were relating to lands in which you have some interest.
Yes, Milords. So I am, in fact, Milords, presently the owners of those lands. But what the private respondent did is, Milords, filed an application saying that my predecessor had purportedly, Milords, forged certain deeds. And basis those, Milords, I was transferred those land. Despite knowing, Milords, that I am the owner, Milords, they did not make me party, one. Two, Milords, they had previously filed a civil suit for declaration that the land, Milords, sale deeds were forged. That suit was dismissed. They don't disclose that also before the learned single judge and fraudulently obtains orders. Milords, that's my sum and substance before the learned single judge.
Therefore, how are you agreed by the order passed in 2576?
Yes, Milords, 2576, your lordship will see para 4.
Yes.
There is a prima facie view that could have either filed a non-party review on challenge or order by way of an appeal. And Milords, the only reason why the learned single judge declined the interim relief was because she was not convinced that this is maintainable. She doesn't get into the merits of the matter. And Milords will see 32 for a moment. It's the same single judge that petition has been dismissed, Milords, altogether on this ground.
No, we are just now on 31.
Please, Milords.
What is the interim relief that you paid in the writ petition? Where is the interim relief?
Yes, Milords, the earlier, Milords, my relief, Milords, your lordship will kindly take, Milords, page 51 of my CAN application. Page 51, Milords. These are my prayers in the writ petition, Milords.
এটা হচ্ছে লাস্ট তোমার কোনটা ছিল Respondent number 5 was the writ petitioner in the earlier writ petition.
Please, my lords. And your lordship, since your lordship is on the can, your lordship will kindly see page 353 also for a moment.
Page 56 L, that is the interim prayer.
Yes, my lords.
What is the order passed in WPA 1911?
Yes, my lords. That, my lords, I'll just is at page, my lords, 61.
What is there to stay?
Yes, my lords, the issue is, my lords, pursuant to this order, the learned BLLRO has initiated a proceeding. And my lords, what is most relevant in this case, if I may just show, my lords, the civil suit which the private respondent had earlier filed. He elected a remedy. He approached the civil court for a declaration that the sale deeds are forged. That civil suit gets dismissed. He abandons that, and my lords, a new remedy now opens without making me party, without disclosing that fact to the learned single judge.
Therefore, we are asking, where is the question of a stay? Let them appear, the court will pass orders appropriately. What is stay
Milords,
can
but
be granted at this?
Till then, Milords,
That
this
is the
order,
final relief that you are, that is the
Milords, what
final
I'm-
relief that you are claiming.
Milords, I bow down, Milords. All I am seeking is, Milords, no effect of this order be given, Milords, because then, Milords, the matters will proceed. In fact, the matter has
But
proceeded.
that is the final relief, sir, that you are claiming. That cannot be granted by way of an interim relief. That's why we asked you, there is nothing. The single judge has only directed them to proceed in accordance with law.
Yes, no, Milords, but there
So
is
how can anyone be aggrieved by that?
the issue is, Milords,
Nobody knows what will happen.
No, Milords, the proceedings
Nobody
have
knows what
ended.
will happen.
The proceedings have ended, Milords. The BLLRO has in fact declared that the sale deeds are apparently forged. That
Maybe, so
declaration has
that,
come.
that can be, that has been challenged by you.
My lords, that has not been challenged in these proceedings. I have separately.
Therefore, we are saying what is to be done now.
Yes, my lords.
You challenge those orders.
I will, my lords, challenge those orders, my lords. But today,
Then
my lords,
what
I am
remains? What
No, my
remains
lords.
here?
The point, my lords, I am trying to make, my lords, everything, my lords, the source or the genesis is these orders of the
We
High
have
Court.
understood what you are trying to say, sir. You are trying to say that the multiple remedies are being invoked and they are without even pleading you, they are obtaining orders.
Please, my
Now, a
lords.
particular order has been passed, you have to challenge that order. One of the
Because-
orders you have challenged, the Red Court is still seasoned with the matter. There is no scope for an interim order.
Yes, my
That's
lords, I
what we are
bow
asking
down.
you.
My lords, I bow down, my lords,
Then-
but kindly, my lords, now see page
You go and
354.
pursue the matter before the Red Court.
No, my
Or
lords,
if you
kindly
want
see.
to challenge the order, you challenge it.
I bow down, your lordship will kindly see 353 for a moment now in that CAN application.
Huh?
Page 353. So, my lords, your lordship recalls I had filed 2 writ petitions because similar orders were passed in 1911 and 1912. Now, my lords, kindly see the order passed in the other writ
We'll
petition that I
come to
filed.
that when we come to that. Don't try to, these two issues are distinct from each other.
My lords, but
They are
may I
regarding
just,
two different. We
May I
are
just
only
sub-
on this. We have not
Yes.
come to the next case yet.
may I just
Yes.
submit this, my lords, because your lordship will
Yes.
see in the impugned order, my lords, the learned single judge has already made an opinion prima facie on the maintainability.
Prima facie is an opinion.
My lords, that's the reason my interim has been declined, my lords. Your lordship will kindly.
Therefore, we are again and again asking you whether any interim relief other than the final relief can be granted to you. There cannot be.
No, my lords, my
There is no
submission.
scope for an interim relief.
The only submission is, my lords, the BLLRO should be, my lords, directed to not proceed, my lords, any further. Pursuant to these orders, my lords.
That is the final relief. So therefore, there is nothing in this appeal. We'll come to the next when we come to it. Take down. The writ petitioner is aggrieved by certain orders passed by the learned single judge, by an order passed by the honorable single judge. Stop. On the writ petition filed by the present writ petitioner. The order is dated 9/1/2026. Full stop. Learned advocate representing the writ petitioner has placed before the court the background in which the writ petition was filed. So it is submitted that some person invoked the writ jurisdiction alleging, making certain allegation with respect to revenue entries in respect of certain lands which are actually owned and possessed by the present writ petitioners. Full stop. The writ petition was filed according to the writ petitioners behind their back and orders obtained thereupon. Stop. The petitioner there, under the circumstances, filed a writ petition seeking recall of the orders passed in the writ proceeding, in the earlier writ proceeding. The order passed in the earlier writ proceeding is dated 23/9/24, passed in WPA 1911 of 24. The direction passed by the single judge therein was to the authorities to take proper steps for correcting the record of rights. Stop. Pursuant thereto, it is the petitioner's case, present writ petitioner's case, that the record of rights have been corrected already. The corrected records, the corrections made in the records according to the writ petitioner are unsustainable, which though not challenged till date, he submits may be challenged in appropriate proceeding in accordance with law. The issue is the order based on which the corrections was made, and the same is the subject matter of the writ proceeding pending before the single judge, wherein an order dated 9/1/26 has been passed in the following terms. We find that the observations made therein are prima facie. Stop. The matter is still pending before the single judge. And the nature of interim relief which the petitioner wants, if allowed, would amount to passing a final order on the writ petition at the preliminary stage. Stop. We therefore find no infirmity in the order dated 9/1/2026 passed in the writ proceeding. Stop. The appeal is dismissed. The petitioner would be at liberty. We make it clear that dismissal of the appeal may not be treated as an expression of opinion of the court on the merits of the matter pending before the learned single judge. Yes, next one.
Milords, would your lordship also consider, Milords, observing that uninfluenced by the observation on maintainability, Milords, because what will happen is, Milords, any judge who takes this up, Milords, will already be prejudiced.
Item number 32.
Just may I add one line, all issues are left open.
Grateful, Milords.
All issues are left.
Yes, your lordship will kindly see
32, what happened?
impute, Milords, here, Milords, my petition has been dismissed on the ground that it's not maintainable and I should file a third-party appeal.
The order dated 11th of February 2026. Order dated 11th of February.
Yes.
Yes,
Already
Milords,
here it has
here,
been dismissed.
this one is dismissed on maintainability and Milords,
Passed by the
that's why
same judge, single judge, but it has been dismissed on the ground that the petitioner was at liberty to file an appeal.
But
By
they
seeking
have
leave
both
to-
remedies under the law, they have both remedies.
My lord?
Under the law, both remedies available.
Yes, my lord, and even this relief is sought against the officer of the block land and land reforms officer, and that is strictly barred under the provisions of the entertaining the same petition by the Honorable High Court, but there is a tribunal, there is a separate tribunal, the land reforms and tenancy tribunal.
No,
Under
that's
the-
not the point. The point is the order passed by the writ court.
Yes.
He is aggrieved by the orders passed by the writ court without impleading him.
But that's
Now
a
he has
separate-
the option of filing a review.
Yes, but in that writ petition, my lord, but not by filing a separate writ petition.
Why not? Why not? That's what we are
That is
asking.
that is the matter that is to be decided by
How
your
do you
lord.
sustain the order? That we are asking.
But because the petitioner has the option to challenge that order by way of an
So
appeal.
why he should be limited to only one option? Why can't he exercise the other? That's what the issue is. The
Well, the-
leading case on this point of review where a party is, where the necessary party is without pleading a necessary party. Perhaps 1963 Supreme Court,
Yes.
1909.
Grateful, Milords,
Shivdev
this is
Singh.
Shivdev Singh. Yes, Milords, my
But
colleague
review-
is carrying that judgment.
Yes.
Yes,
Well, the
my
review has
colleague
to
is,
be before the same judge, my lord.
no.
Obviously, so why he can't?
Well,
file it?
this is passed by a different judge, my lord. So it's passed by Justice Shankar Sarkar, my lord. The original order, my lord, that is that it is impugned in this writ petition, in the earlier writ petition that was passed.
Sir, what he is saying is there are two cases
Yes,
in which there are some revenue records which have been manipulated.
yes, my lord.
And
those
for
are the-
that, they have approached the writ court.
Yes.
In one case, he has filed a review, it has been entertained. In the other case, it has not been entertained.
No. That is not the case, my lord.
Then-
In both the cases, the review has not been filed. They have filed a separate writ petition seeking
That is
review.
what we are saying.
These are two separate writ petitions which have been subsequently filed. Initially, there were two separate.
Review under Article 226.
Yes,
It is settled since 1963
Yes, my lord.
Supreme Court.
seeking review of the order passed in a
Yes.
separate writ petition.
Yes.
Two separate writ petitions were
That's why
filed.
why it has been interfered, we don't know.
And my lord, the
Is there any
earlier,
private respondent also?
I'm sorry, Milords.
Is there any private respondent?
Same,
Yes.
Milords, it's the same writ, original writ petition happens to
the
be
private
same in
respondent
both.
is the writ petitioner in the earlier writ petition.
And they have here the matter is already disposed of.
Yes,
Yes,
it is
Milords,
dismissed. It was
that's-
dismissed.
And Milords, we'll see the earlier WPA here is 1912. So there were two connected
Yes.
matters.
That is at page 350, my lord. The earlier writ
You want
petition.
to file any opposition?
Obviously.
Then file it will consider.
Your Lordship, this is on
Let us-
question of law, Milords. I have, Milords, settled, Your Lordship indicated, Milords, Supreme Court
So
Constitutional
without
Bench.
opportunity, we should proceed.
No,
No,
Milords.
without opportunity, we should proceed. Let an opposition be filed. To stop the learned, start with the learned advocate for the writ petitioner submits that issue of law is raised in the appeal, whether the petitioner can be limited, whether the petitioner's discretion to avail remedy can be limited to one out of the several remedies available by an order passed by the writ court, which is impugned in the present appeal. The learned advocate for the respondent submits that they will file an opposition. How much time? 1 week?
But 2 weeks.
He seeks 2 weeks for filing an opposition. List in the next available circuit.
Grateful.
Grateful, Milords.
Grateful.
Item number 33.
Altipty was affirmed on Millard, probably Thursday or Friday. We could not complete the service, Millard. Millard, kindly takes it up on the next
Service.
service. And I am also not prepared, Millard. Kindly take it up on the
When?
next week, Millard. Okay, next week. Let it be on
Monday?
Thursday, Millard.
Thursday, as paid list on Thursday.
My lord, my lord, sorry for disturbing, my lord. My lord, item number 17, my lord has made it returnable on 12th of May. My lord, can it be 13th? My lord,
The site is present.
my lord, my learned friend.
For the,
Item number 34.
somebody else was also appear.
My lord, Mr. Joyjit Chaudhary, we had a talk with him over phone. He has no objection.
13th.
34.
Date.
Item number
Item 17-18.
17 to 19.
17 to 19 instead of 12. 12 May.
Yes. 12 May bodole 13th May.
13th.
For filing affidavit. For filing affidavit.
That was not the case.
13th May.
Next date is fixed as 13 instead of 12.
Item number 34.
Praying for not today, Lordship.
My lordship, in item number 34, there is a suspicion regarding their service. They have serviced with the other rate number. I have got only through this name, I got the.
There is no order till date. It's come for the first time.
My lordship, apology, this lordship.
Why are you taking Passover?
Lordship, my senior is out of station, Lordship.
Not with.
Item number 35.
Impugned order is annexed to the last of our certified copy.
Yes, what is wrong with the order?
Lordship, this applicant purchased the landed property by virtue of the registered entity. Page number 21 of my annexure is the stay at.
Yes.
It was purchased on 28/4/2014 that the land has been registered before the registry. Thereafter, the name of the applicant has been entered into the record of right. And Khatyan in her name has been published. Thereafter, one information came into the notice of the applicant that the land has been acquired by the respondent number six, Special Land Acquisition Officer Jalpaiguri, for the purpose of laying some underground pipe on behalf of respondent number 4, Lordship. Thereafter, one representation has been made by the husband of the appellant to the Special Land Acquisition Officer on 4th April 2023 that if the land has been acquired, so compensation may be given. I didn't hesitate regarding that acquisition. Thereafter, one reply has been corresponded by the respondent number 3, respondent number 6 on 26/5/2023, page number 36. With reference to the above, this is to inform that 0.1408 acres of land has been acquired for ROU in plot number 403 Mauza Jalpaiguri, sheet number 20, and the compensation was paid to claimant after verification in possession of ROR, your name is not found in this present list. My name is recorded in the record of rights. And subsequently, we got the information that during pendency of that writ application, that the compensation has been received, page number 39, Lordship. Second paragraph, Mr. Frazan Ali, care of Mohammed such and such, and Miss purchased the property from Jaleka Thakur. Which was registered before the registering authority on 28/4/2014. Subsequently, another report has been came from the end of the state of West Bengal, page number 41. The 13th December 2020, in the first paragraph, that the land has been acquired. So my land has been purchased in the year of 2014. Land has been acquired in the year of 2020. How the predecessor of my landed property had received the compensation from the concerned authority and saying that my name is not recorded in the record of right, whereas my Khatian is there, is the page number 33. So only the prayer of the petitioner before the trial court that has been rejected by the impugned order, that the name has not been recorded, the name has not been found in the list. That's why my writ application has been rejected. Whereas on the document, in the year of 2020 that the land acquired, in the year of 2012 I purchased the property, and the compensation has been given.
14 you have purchased, not 12.
2014. But
So why can't you avail the remedies under the Land Acquisition Act?
well, this acquisition was basically for a pipeline of the gas authority. of
Whatever
India.
it may be,
Well,
he is claiming to be the
compensation amount is
rightful
already
owner, he
been-
has to avail his remedies. How the report can be?
Yes, already paid to the recorded owner.
We
Yes,
don't know whether he is the rightful person or not.
he has to go before the
How
civil
it can
court
be
seeking
considered in a writ?
No, here the report, as per the report, I can understand that my name is not in the list. So this is not my fault, Lordship.
Let us take your name is in the list. Still it has been paid to someone else. What the writ court will do? We are saying you have to avail the remedy under the statute. Some wrongful person has claimed, we don't know. Maybe you are correct. How the
No,
writ
not
court-
wrongful person, my predecessor.
So according to you, he is not, he
As
is
per
not
the
the,
report has.
see, according to you, he is not the owner of the land. So he is a wrongful person today. Because he has already parted right title and possession and you are now the right title and possession of the land. So he is a wrongful person. So then what is to be done by the writ court? That we are asking. At best, we can say that this order will not prejudice your rights if you avail the remedy. What else can be done? This is the order. And what is this? The court has recorded that you were asked to come back with some instructions. You have not told the court. What you were required to do?
Yes, Lordship. Keep it another.
Paragraph 3 of the order, what were you required to do that you did not do?
Keep it another day, I will come with the.
No, what another day? Just see paragraph 3 of the order. Writ record is here. Writ record is here. Writ record is. In this place without the writ court order. Record.
Actually, the order, date was fixed for order. And my junior appeared before the court.
So you
Before
have
that, the hearing has, full hearing has.
So under which provision he is required to avail the remedy?
But since the payment has been made allegedly to a wrong person, He used
We
to
are
see,
asking you which provision under the Land Acquisition Act?
oh, this is not under the Land Acquisition Act. This is under the PNP Act, Petroleum Minerals Pipeline Act. Here the land has not been acquired. Only the right of user has been acquired. The pipeline goes beneath the land.
There is no acquisition of.
There is no acquisition as such. There is right of user.
No, but
Acquisition
then
of
his
of
right gets restricted because.
His right gets restricted. He is unable to build anything over the land concerned. But he can, if he has any residential premises, he can reside there. If he has any crops on the land, he can cultivate that crops.
PMP Act, what is the provision? Let us see.
Lordship, in the page number 40, it is categorically stated that the land acquired. This is the report of the Special Land Acquisition Officer Jalpaiguri is the party in this application. Page number 40. With reference to the above, it is such and such acres of land have been acquired for other.
You have copy of the writ petition.
It is annexed to the stay application. That's why I filed another stay application. Only to annex the document.
No, the writ petition is not here. Documents are here.
I have a just offline online copy, Petroleum Minerals and Pipeline Act of 1962. Lordship, this is my writ application. Copy of that.
Let us see.
ISO 6.
Maybe it is the page number 33.
Or by PMP Act. We could have seen some.
Later dated 26/5/2023. Lord.
এটা লিখিন এটা এটা প্রপার ব্র্যাকেটে ওটা আছে রাইট অফ ইউজার Okay.
This is the application that.
My lord, I have a copy of the notification itself. My lord, may take a.
Where is the application you made before the authority?
Past representation, page number 32. My husband made the representation.
until thing.
The application page number 35.
It's fine.
You lost an FIR also.
You purchase the property from Jalpaiguri.
Yes, sir. And as per the order of the trial court, Jalika Khatun is also made the necessary party in this application before the.
Yes.
But I have the copy of the act with me. But the declaration is made under section 6, that is declaration of acquisition of right of user. Under section 6 of the PMP Act, that is the Petroleum and Minerals Pipelines Acquisition of Right of User in Land Act 1962. My lord, as per the provisions of section 6, my lord.
Oh,
If I
this
may
must be a very common thing, somebody else taking the.
My lord.
Then what is
And
the remedy?
any issues relating to compensation, whether the amount or whether the compensation itself has to be determined by the district judge concerned, my lord. There's a provision in the act
That's
to
what
go
we
for
are
the
asking you. We don't have the act. We are asking. you
Yes,
where
my
is
lord,
the-
I have a soft copy of the act, my lord.
Which provision deals with this issue?
My lord, I'm referring to section 6 of the act, my lord, wherein the declaration of acquisition of right of user has been made. My lord, if I may read the
Dispute relating to compensation.
compensation, my lord.
Which provision?
My lord, that is section 10, my lord.
What does it say? Please read.
Yes, my lord. Wherein exercise in subsection 1, it says, wherein exercise of the powers conferred by section 4, section 7 or section 8 by any person, any damage, loss or injury is sustained by any person interested in the land under which the pipeline is proposed to be or is being or has been laid, the central government, the state government or the corporation, as the case may be, shall be liable to pay compensation to such person for such damage, loss or injury, the amount of which shall be determined by the competent authority in the first instance. If the now subsection 2, if the amount of compensation determined by the competent authority under subsection 1 is not acceptable to either of the parties, the amount of compensation shall, on application by either of the parties to the district judge, within the limits of whose jurisdiction the land or any part thereof is situate, be determined by that district judge. Now, my lord, comes subsection 3. The competent authority or the district judge, while determining the compensation under subsection 1 or subsection 2, as the case may be, shall have due regard to the damage or loss sustained by any person interested in the land by reason of removal of trees or standing crops, if any, on the land while exercising the power under section 4, section 7, or section 8, and the temporary severance of the land under which the pipeline has been laid from other lands belonging to or in the occupation of such person, or any injury to any other property, whether movable or immovable, or the earnings of such persons caused in any other manner. Provided that, this is the proviso, in determining the compensation, no account shall be taken of any structure or other improvement made in the land after the date of notification under subsection 1 of section 3. Now, subsection 4 states, my lord, where the right of user of any land has vested in the central government, the state government, or the corporation, the central government, the state government, or the corporation, as the case may be, shall, in addition to the compensation, if any, payable under subsection 1, be liable to pay to the owner or to any other person. And this is to be noted, or to any other person, any person who claims to be the owner, whose right of enjoyment in that land has been affected in any manner whatsoever by reason of such vesting, compensation calculated at 10% of the market value of that land on the date of the notification under subsection 1 of section 3. Now, subsection 5 deals with the market value, my lord. The market value of the land on the said date shall be determined by the competent authority, and if the value so determined by that authority is not acceptable to either of the parties, it shall on application be by either of the parties to the district judge referred to in subsection 2 be determined by that district judge. And subsection 6 says the decision of the district judge under subsection 2 or subsection 5 shall be final.
That is a different thing. That is.
Well, there is that is with regard to the compensation that is being paid. Well, there is no other provisions. No. Look, there is another provision, if I may refer to it. This is in section 11, that is under the heading deposit and payment of compensation. My lord. Subsection 4 states specifically where several persons claim to be interested in the amount of compensation deposited under subsection 1, it is to be deposited by the requiring body. The competent authority shall determine the persons who, in its opinion, are entitled to receive the compensation and the amount payable to each of them. So, my lord, here in this case, several persons are claiming the compensation.
That chapter is over by the, as per the document number 36.
No,
the
no.
name is not there.
So you have to establish there how it can be done in a bit.
And my lord, subsection 5 of section 11 states if any dispute arises as to the apportionment of the compensation or any part thereof, as to the persons to whom it shall be payable, the same or any part thereon, the competent authority shall refer the dispute to the decision of the district judge. That is what I was saying, my lord. Within the limits of whose jurisdiction the land or any part thereof is situated, and the decision of the district judge shall be final.
That is the quantum of compensation.
No, not just the quantum of compensation. It is with regard to even the as to whom it is payable. That is also to be decided by the district judge. Quantum of compensation, that is in section 10, and this is in section 11.
Section 11.
Yes, section 11, subsection 4 and subsection 5.
Yes, my representation has not been referred to the district judge. Directly it has been.
No, it
referred
cannot
to-
be referred to the district judge. You have to apply before the district judge. Cannot be referred to the district judge.
Who is the competent authority under the act?
No, the competent authority is the special land acquisition officer. There's a state authority, there's a acquiring body.
You have to agree with the state. Is agreed by the order under the field is dated 22nd to 26. Stop. The brief factual background leading to filing of the writ petition was acquisition of certain lands for user rights to be exercised by the Gas Authority of India Limited. Stop. The acquisition for the purpose was done by the state authority. The writ petitioner intimated the state authorities that he was the person holding right, title and possession of the lands in question by virtue of a registration dated 28/4/2014. He received an response from the land acquisition section of the Office of the District Magistrate that compensation for the lands bearing plot number 403 at Mauza Binaguri has been paid to the person, to the claimants whose name figured in the possession list. They say possession list.
Record of rights.
Huh?
Record of rights, ROR.
No, something possession list was.
Yes, verification of position and ROR.
Possession list.
Well, this is the verification of position if I hand over.
Position.
Possession
As
list.
per the-
Item number 36.
Appear for the respondent.
না না আমরা রেসপন্ডেন্টই, আমরা পিটিশনার ছিলাম না।
Let us.
Now it is, this is also being told to the court. In our younger days, we were never dared to say that my senior is in other court. And that hardly a piece of business somewhere. The order of demolition effected by the authority, the dilapidated judgment delivered by the honorable single judge.
Your property was being demolished.
My case is, I am the landlord, this is the tenant. Tenant had made a construction after the original tenanted premises was curtained by fire. He constructed without any sanction. The honorable single judge taking pain, 3 sections he has quoted where any construction, definition of the building is there. On the basis of that, he cannot make construction without any sanction plan. Now this should be the model.
কি তো ছিল
You are for the corporate.
আমারটা কোথায় গেল?
এটাই তো
Server copy.
কোনটা তো সাবমিট করেছে?
You have already sent the notice.
কি জানি আমাকে তো এটাই দিয়ে গেল কালকে। এটাই ছিল যেটা মেমোটা এই
ঠিক আছে, মনে আছে আমার।
হবে না নাকি কি বলে হবে? This notice was at your instance. The notice sent to them was at your instance. Yes, what is the problem? Take time. You want it tomorrow? Not today.
Only one thing, my lord, is paying, I never stand opposite by the actual way. But, showing this pendency, my lord, the authority is not any expense.
You know better.
My landed friend is here, so I made this prayer in presence of my landed friend, so that
I shall be candid because of model code of conduct. Whatever you done after the election.
model code of conduct also says the demolition process stop.
Don't know the.
Please show me, I have never come across.
Anyway, that's not before us.
That cannot be.
That's why we said, you know better.
Item number 36, 37.
Absolutely, it's not their fault, it's not all the respondents, but they do like a respondent about the was not given back to the center. Instruction and seeking liberty of this order is that serving about the council who had appeared for the respondent liberty.
Come to the order, let's see what the doctor. Dismissals.
Yes, yes, sir. We are informed by the learned advocate for the appellant that service is incomplete. Stop. We adjourn the matter for completing the service and filing an affidavit in this regard by oh, what is the delay? No, the cause title is also defective. Copy of the sets for this. So to serve it on the, yes. So the notice in the appeal and the application. Come back after you serve. We also permit the learned advocate for the appellant
to cure the other defect pointed out. In the meantime, list on Thursday.
Item number 38.
Tomorrow. I'm not finished. Tomorrow is not.
NTD. Day after two.
Yeah.
39.
For the petitioner, my lord. 39, my lord, I am for the petitioner, my lord. In this matter, some defective in this matter, my lord.
Today, mineral batches are 96. In short, and Minerals Pipeline Act 19. P and MP Act. P and MP. Like all the pipeline. Pipeline. Yes, who is the paid for the appellant? Who is
I am
the
for
you
the
are appearing
petitioner,
for the
my lord.
appellant?
I am for the appellant, my lord. Item number 39. It is not here. It is incomplete. 3 earlier occasions. Very sure about 3 earlier occasions. Yes, what do you want? My lord, in this matter, is some defective error, my lord. I am praying for a next circuit, my lord.
No next circuit. What is the defect? Let us see. No next circuit. Enough is enough. One day we are condoning. You address us on merit.
My lord, kindly fix the next week, my lord.
Yes, tomorrow.
Tomorrow.
Not today.
Item number 40.
Number 17 to 19. Some other teachers are to be affected by the order dated 24th December 2025.
Teachers. Oh, that matter which one?
17 to 19.
So list along with that case.
So only one defect has been mentioned as to this matter. In number 145.
Her name is Sunita Liu. She is appearing in the first list as item number, as record number 174. But we could not find it. That was
200 and
174. That is there in running page. What? 39. No, the fragment copy of this. Fragment copy, I think, is there in page 39.
paragraph.
It is the first second. 174. The certified copies are bulky one because of the many copies are taken.
179, what it is?
174.
The cost. Name of the address for number 145. No, you have not seen it properly. There is some added respondent number 145 in the impugned judgment, whose name is not appearing in the cause title here. When those matters have been adjourned? When those matters have been kept? List on 13 along with, please give that case number. What was it? Today item number?
1789.
As jointly played, list on such and such date along with those. Yes, call the next.
Understood, Your Worship. You rectify it. Okay.
Item number 41.
Item 41, I'm paying for next circuit, Lordship.
Lordship, I am
Lordship,
requesting
the
Union of India,
conducting-
respondent.
The conducting counsel, Mr. Jha, his cousin brother has passed away.
Lordship, in the last circuit also. the
Mr. Ronit Kumar Jha. Ronit Kumar Jha.
We are informed that the Legal advocate who is to appear in this matter has suffered a bereavement in his family. List in the next circuit.
NCB.
Briefly apply.
42.
Defect is already cured. You were asked to cure the defect in February, then in March again, there is not nobody appears to be, or you are not interested. This is not enough time. From February till April is not enough time. You are not interested, then why to keep it pending?
কোনটা থেকে নিলি?
Your Lordship, fine next week, Your Lordship. Need to accept and trying to cure the defect, Your Lordship.
Currently, you are not interested.
No, Your Lordship, I have been informed.
Keep the matter pending.
I have been informed today, Your Lordship, by the conducting advocate.
Today again is a prayer is made for time to remove the defect. Stop. This court on 20.02.2026 granted time for curing the defect. Stop. No steps were taken. Stop. On 16.3.26, stop, comma, when the matter appeared, there was none to represent the parties. Stop. In these circumstances, by way of last indulgence, we are adjourning the matter for 2 weeks to take appropriate steps in accordance with law. Hmm. Right. 43. None of yes. On behalf of either parties, get rid of this Thursday. No. This has already been amended. 44.
Lordship, I'm on the behalf of the petitioner, Lordship. Lordship, from the cause list, it appears to be defective, and we are praying for a considerable time for curing the defect, Your Lordship.
You are the red petitioner.
Lordship.
You want it from an earlier period.
Lordship, condemnation of delay has to be filed for curing the.
File is-
Yes, Your Lordship. We want a considerable time. Also, Your Lordship, it is prayed if it can be kept out of the list because it will take some time.
This 23-day delay will take some time, 32 days.
A bit, Your Lordship.
Why? Get it done.
Because there is a miscommunication with the client. That is the problem with this. That is why we are praying for the same.
No, we are not going to delist it. Let a condemnation application be filed as paid for. List after 1
Grateful,
week.
Lordship.
Yes. After 1 week, let it come on Thursday. 16. Solo.
$45.
For the appellant. My lords, I beg to appear for the respondents. My lords, the advocate on record is on his legs before courtroom number 5, lordship. Praying for a short passover, lordship. My application can 2 is for substitution of the appellant. The appellant has died after filing of this appeal, and this application is pending. Can 2.
Otherwise, service is complete.
Yes, my lord, he is appearing for all the respondents. I have also subbed this a copy of the can 2 upon
Just
the advocate on
give
record.
us-
কিন্তু সবার হয় না কিন্তু বলছি না।
Yes. You have to say about the substitution.
I am not aware of the facts of the case because my lord, I've just been requested to pay for
You have not filed any opposition to this. Have they filed?
No.
You have served the copy.
Yes, ma'am.
Copy has been served on you.
Actually, I'm not the advocate on record in the present case.
It was served by hand to the advocate on record.
Let him be here tomorrow. No.
Grateful, ma'am.
Item number 46.
Lordship, I am for the appellant. Lordship, in this matter, Mr. Shankarnath Mukherjee is supposed to appear, Lordship. Paying for time, Lordship. Kindly taken up the matter on next week, Lordship.
That's pretty listed in the next.
Item number 47.
Lordship, Lordship, in item 47, there is a defect and it was we were directed to file the copy of the original order and judgment. Lordship, we have already applied for the certified copy, but we haven't acquired it yet. If you, Lordship, will kindly give me 1 week's time, then I will be able to file that.
There's so many defects.
Yes, Your Lordship, due to not annexing the that title to a copy of the title suit and the judgment and order arising out of the title suit, this defect had been
Limitation is
arised.
also there. Limitation is also there.
Yes, Your Lordship. Lordship, I need to file that certified copies, otherwise we cannot proceed.
Certified copy of the decrees.
Certified copies of the title suit and the judgment and order arising out of the title suit. We have only annexed the appellate order.
Judgment and decree of the first appellate court,
Yes, Your Lordship.
as well as the trial court.
Yes, Your Lordship.
In the next Sunday.
Grateful.
NCB. Item number 48.
48, Lordship, Mr. Conmoy will be appearing in this matter, but due to his personal difficulty, I'm paying a week's time, Lordship, and there have been subsequent events. Those have to be brought on the record, Lordship.
Landed advocate, Mr. Swansford, that some events subsequent to filing of the appeal has spread list in the next. Don't write it.
I don't know. 40 then 40.
50 also.
Next.
Item number 49.
I'm for the appellant, not, actually there are some defect in the applications as well as services you got to email. Because this was first time it's appearing before the court. Actually, the appeal is in respect of an application filed before the district judge which we are regarding revocation of the probate. That was admitted by the district judge subsequently, and the other side has appeared and just verbally said that it is going to be decided by the district delegate, because district delegate has heard it at that first point of time. Regarding that, the district judge has stated that it should be appropriate forum for district delegate to hear the matter. Against that order, we have appeared before this court because there is a judgment of the reported judgment of this coordinate bench that district delegate has no such power regarding application of the revocation of the probate. That's application that was passed by Honorable Justice Jyotinmay Bhattacharya and Honorable Justice Demi Prasad De. May I praise the judge? Manual, this Calcutta High Court. Paragraph 23 is relevant. Other parts are also relevant. The order, impugn order is there.
Oh, delay, there's a delay. 1434 does it.
There is a delay, Your Honor, because we have filed a CO application because jurisdiction order was there. Subsequently, there it is in withdrawn and filed.
Whatever it is, you have to file an application.
The delay application has been filed here.
File.
Yes, ma'am. We have filed the delay.
Can number?
One is the stay, one scan application is stay, other is the delay.
One must be the condemnation.
Delay has been filed, ma'am.
And deficit of court fees.
Two can application has been filed, one and it was not numbered here, and that's why it is difficult.
Yes, can one is the condemnation
Of condemnation application, and can two is the stay application.
Appellants are represented by the learned advocate. The appellant
Item number 50.
50, Lordship, in this matter, Tanmay Chaudhary will appear. This is as similar like 48, item number 48, Lordship.
What he did in 48?
Yes, Lordship. There has been some new facts which needs to bring before the court. So, Lordship, in item number 48, give the order.
Yes.
Read from Lordship.
48.
Yes.
51.
51, my lord, I'm for the appellant. My lord, the cause list shows that the matter is defective, my lord. My lord, section 5 application is yet to be filed so far as my knowledge is concerned. My lord,
Steps for hearing the defect. Just in the next one.
Next week. Item 52.
in 52, my lord, I'm for the appellant, my lord, praying for just 1 day accommodation.
Great.
The research lawyer on the respondent. In? He wants not today.
52. Later with the file. SAT 4. Not today only. 53.
53 minutes, there appears to be some defect, my lord. I'll cure the defect, my lord. Can you place the matter on Monday?
Next one.
There are many defects.
Many defects, my lord. I'll cure it, my lord, within this week.
Hmm?
I'll cure it within this week.
As prayed by learned advocate for the applicant. We grant a week's adjournment for removing a defect list after 1 week.
I'm great.
Solo char diye. Solo char. 54. Not today.
All appears on behalf of the appellant.
Your Lordship, in
55.
item 55, I am appearing for the appellant, Your Lordship. there were defects which were marked by the registry. We have cleared the defects, Your Lordship. In the order dated 18th of February, the defects leave was granted. Your Lordship, the stay application could not be filed. I was seeking leave to file the stay application, and if the matter could be adjourned for a week.
We are informed by the learned advocate for the appellant that stay application is to be filed.
I know.
All defects have been removed
Yes,
Your
my lord. we
Lordship,
have
all
removed the
defects have been
defects.
removed.
and adjournment is sought for list in the next subject.
Obliged, Your
Grateful, my
Lordship.
lord.
56.
None of these are the applicant. This one. Next. 16.
Item number 57.
I'm praying for not this week.
Hey, madam. Why?
Lordship, there is a defect in this application, so we have applied for the decree. We did not receive the decree yet, so kindly grant adjournment.
As paid staff for 1 week.
Lordship.
Solo, sir. 58 and 59.
Yes, call the next. Call the
60.
60. My lords, this is an appeal under section 37 of the Arbitration and Conciliation Act. I'm led by Sagar Bandewar, the senior advocate. He happens to be the returning officer this election, Bar Council election. So if it can be fixed on Friday, this Friday, as your honor, if your honor can accommodate.
As paid list.
Because it requires to be heard by physically coming over here. Virtually, it cannot be done.
Next week.
Friday, my lords, Friday.
Next week. You come on Thursday. 16th. 16th.
16th. 16th is Friday. Friday. Thursday.
Oh, you want on Friday only?
In Fridays.
17th.
Great fine. 17.
Item number 61. 62. 62.
My lordship, this is a case for restoration. There is a delay of 103 days. Notice has not been complied to the opposite party. So praise for that.
For filing affidavit, for taking steps to ensure service of notice and filing of affidavit of service, we allow the learned advocate 2 weeks.
$63. 64.
Not on paying for 1 day's accommodation.
Yes.
64.
Lordship, I am appealing for the appeal. Lordship, these in restoration application indicates. Paragraph 5, I have stated. Appearance to the area.
Can free is restoration.
Restoration. Paragraph 5, I have stated. Application to
Who is the advocate on record?
Lordship, the present advocate on record is Mr. Mitro.
And on that day?
Lordship.
And on that day when it was dismissed?
Mr. Shongram Sinha. He retired from the brief.
He has given a no objection. He has given you a no objection.
Lordship. Wakalatnama 5.
Being as first name as the erstwhile advocate on record.
There is no objection.
Lordship, he stated that he don't have any objection in this case if my learned friend is appear in the matter.
That is the way to give a no objection.
Wakalatnama not there?
Wakalatnama does not bear any no objection.
I understand, Lordship.
So, how you can say what happened on that day?
No, I just read out the petition, Lordship. Yes,
Sir,
I understand, Lordship.
If somebody else has filed the application for recall,
yes,
how he can say what happened on that day when he was not an advocate on record, when he was not appearing?
That's true.
How he
Lordship.
can say?
No, I thought that there is no objection. I'm sorry.
Therefore,
I'm sorry,
we made a
Lordship.
specific.
I'm sorry,
Please
Lordship.
have a look at the Wakalatnama.
No, since your Lordship is
No,
there,
please have a look.
I understand, Lordship.
Yes.
I don't know.
How it can be considered like that? You know very well.
Lordship.
Cannot be.
Lordship, let the petition be withdrawn and fresh petition be filed upon taking the case.
No,
Lordship.
please have a look.
It is not there.
Not there.
Not there.
The learned advocate withdraws the application with liberty to file the same afresh Stop. 64 চলছে তো এখন। The same is permitted to with liberty as paid.
হ্যাঁ 17
These are appearance is the grateful lordship.
Item 65.
Yes, Lordship, in this matter, I am led by Mr. R.C. Guchaid, Lordship, from the Principal Bench, Lordship. Lordship, there is a direction to file the paper book, Lordship. Lordship, some documents we obtained from the lower court record, Lordship. And Lordship, last occasion, there was no direction to, no direction has been given to the landed court below to TCR, Lordship.
Who did that?
If TCR is come here, Lordship, we can obtain the certificate copy here also, Lordship. Kindly give it, leave and give it to the appellant, Lordship.
Lordship, I am on behalf of the opposite party, Lordship. On 6th January, last order was passed, my lord. Item number 65, my lord.
There is no. That's the case. Incorporating all the papers used before the land requires code under section 18 of land. Reply has been filed.
Yes, Lordship.
Yes. And on 6th January, order was there for filing the paper book, my lord.
You are the state, you don't have the record.
Yes, Lordship, we have the only judgment and decree, Lordship. Call for the record, Lordship, but
But you are the director to file a paper.
yes, Lordship.
File it.
Lordship, kindly direct that within 2 weeks we have filed, but if my lord direct to the TCR, Lordship, TCR here come, Lordship, and we obtain the certificate and file the paper book, Lordship, all the
Why
documents.
not obtain it from there? Why it should come here?
Well, so far my instruction, Lordship, file is not traceable, Lordship, that's why.
Then how it will come here if it is not traceable?
If court direct, then
You are a state, take all steps. You are not a private litigant. Then the matter for 2 weeks. Comply here on 6 months.
Grateful, lordship.
Item 66.
I'm for the appellant. This is an application is pending, my lord. I have filed an application for addition of party. My lord, the testator has 4 sons and the testator has some 4 sons, my lord. And they are beneficiary in the for the will. The will. But this for the bona fide mistake, the name is not made as a party of this appeal, my lord.
And this was observed by the Honorable Court, and subsequently Honorable directed to add them as a party. When an application was filed, my lord, by the appellant, and subsequently there was some defect, and that was withdrawn, and the Honorable Court gave us liberty to file a fresh application. This application is filed, my lord, subsequently. Two son, my lord, was died after order of the probate, my lord. And now the appellant wants to add the legal heirs of these sons and the other two sons.
Last order is of 4th November.
Yes, my lord.
You'll put respondent.
Executors.
File a fresh.
Already filed fresh, my lord.
Can number 4.
Can number 4.
What's here it is? No, not today. Well done. And they.
Not today.
Huh? Done.
Oh, it's not today.
Oh. They are the sons of the testator. They are the sons of the testator.
I am the daughter-in-law. Daughter-in-law of the testator.
You want to impeach the grandson?
Hello?
You want to bring on record the grandson?
Grandson.
The sons of
Grandson and sons and grandson.
grandson of the testator.
So sons already there is an order that they are left out, they may be implemented. Now he's saying the grandson also must be.
Because two sons has already been dead. After
Under the earlier order, the court said that those who have been left out because those were parties to the probate proceeding. Now he wants to implement the grandson.
It will come.
It is, they must be on record. So it's
10/4/2026.
Item 67.
Lordship, paying for not today. Grateful, Lordship.
68.
Addendum 60 time for the appellant. There is a direction to serve upon the respondent whenever cost service. Refresh service which was directed. But the issue involved in this matter is that there was a divorce decree passed under section 13B of the Hindu Marriage Act between the parties concerned. And my lord,
13B appeal.
yes, my lord, this is the peculiar circumstance wherein the consent of the wife in the said 13B application was obtained by coercion. And subsequent thereto, she appeared before the court also. She deposed. I have already stated everything is there on record. I have stated the facts clearly. But she was well within the control of her husband at that point of time. She was put under duress so as to depose before the court in the manner as the husband directed. And that is what she did before the learned trial court below. Consequently, the divorce decree was granted. And subsequently, upon granting of the divorce decree, what happened is that this appellant herein was handed over to the father of the petitioner upon the passing of the divorce order. So,
Who are you?
my lord, I am the wife. I am the wife in the said 13B application. And my lord, the entire application that has been made before the trial court is full of suppression of material facts. My lord, I have a son who is 9 years old. That child has been suppressed in the said application. No mention of the child has been made. The date of marriage that has been wrongly stated in the said application. Total incorrect date of marriage was there because I was married. It is the fact that I was married when I was barely 17 years old. I begot my child within 1 year of said marriage.
But you were there in the proceeding?
Yes, my lord. I have stated that in my petition. I was there.
You were there in the proceeding?
Yes.
You must have signed the.
Yes, my lord. I have, my lord.
We allow this then in every.
My lord, this
will become a practice.
My lord, I don't
If
want
you
that.
change your mind subsequently,
No,
you can come and say all
that
this.
is not the case. No, there has been suppression of material facts, and there's also been a consummation during the.
Means if behind your back, then an issue of suppression may arise. When you were very much present and in your senses.
Yes.
Then how you can be a
My lord,
suppression?
I was totally put under duress by my husband at that point of time, and my lord would take this matter into
Done on
consideration.
one day.
My lord, only there was one day when I had to come before the court and depose before the court. My lord,
It
takes up.
involves a rigorous process.
Yes,
We all know what it is.
My lord, just
It is
allow
not
me.
that simple.
My lord, just allow me 5 minutes. My lord, what has happened even during the pendency of the divorce proceedings was that there was a consummation and I had begotten a child.
That's what
That
we are
child was
saying.
also
That's what
aborted.
we are saying. If somebody changes their mind, and then we have to open this new forum.
And my lord, that child was also aborted
Change
during
of
the.
heart will not affect the decree.
My lord, this is not just a change of heart. I was forced into
Precisely what
submitting.
you are saying that subsequently it was consummated. Now a child is born.
It was not subsequently, my lord. It was during the pendency of the divorce proceeding. A child was. I conceived a child. My child was. I was taken to the nursing home. Well, I have all stated all the facts there.
What is the date of the decree?
Well, the date of the decree is 16th of September 2025. 25.
You file evidence, deposition, were examined.
Yes, that I admitted, my lord. That I have specifically admitted because that I cannot deny that. I have filed my evidence in chief. I have appeared before the court below. I have tendered my evidence before the court below. It's a peculiar circumstance in which I come before your lordships.
So.
My lord, I have a 9-year-old child. My lord, that has been deliberately suppressed in the.
I don't know how you are saying all this. You are saying the decree is of 25.
Yes, my lord.
And you are saying you have a 9-year-old child.
Yes, I have, my lord. That cannot be denied. That is a material fact. I have the birth certificate also. I have enclosed the birth certificate of the child also.
So what? You have a child, you cannot go for 13B.
No, that is not the case. My lord, if the child had been disclosed,
How that is
my lord,
relevant?
if the child had been disclosed, then my date of marriage would have been during my minority. Because the child was born at during such a period. My lord, takes up the petition itself, my lord. The petition, the divorce petition itself, wherein it has been stated, my date of birth, my date of marriage has been stated wrongly there in the side petition. My lord, my date of marriage has been stated as 8th of March 2019. এটা কোথায়? বলে birth certificate টা? And my lord takes up the birth certificate which I have annexed as at page 25. My child was born on 9th of February 2014. So my marriage could not have been solemnized in 2009.
Before marriage, already you had a child before marriage.
No, this is from the same person. It's from the same page. That cannot be the case. So that is why I have stated my date of marriage has been wrongly mentioned there. My marriage was not solemnized in 2019 as.
What we are primarily observing is that you have a child prior to the date of marriage.
Yes, my lord.
Cannot lead to an irresistible inference that he is a child born from the same parentage, and all that has been suppressed.
He's a
That
child.
cannot lead to such an inference.
Well, the name of the parents are mentioned in the birth certificate.
What is the date of the birth certificate?
My lord, the date of birth is 9th of February
What is
2014.
the date of the birth certificate?
Yes, my lord, it is dated 19th of February 2014.
Where is that? Which page?
My lord, page number 25, annexure A4. And then stay application, my lord. In my stay application, my lord. My lord, towards the bottom part. Rajdeep Rai is the name of my son. Towards the bottom part, date of registration, my lord, 19/2/2014. It's not the case that it was registered subsequently. And father's name is also mentioned there, my lord. Name of the father is the respondent hearing.
And the date of certificate?
My lord, that is at the bottom, my lord, to find in page number 25, date of registration. This is 19/2/2014. Towards the right hand side bottom. Right hand side corner, just above the signature of the authority concerned.
It's served on the advocate or?
Yes, my lord, it was directed by a coordinate bench.
Where is that service?
It's already there in affidavit of service.
Hearing on behalf of the advocate of the learned child. Hi, the learned child, advocate of the learned child will communicate this thing to the respondent's son. They did not receive, he did not receive.
And my lord, my date of birth has been stated in page number 23, my lord. That is the school
What do you mean
certificate.
has been stated? You have stated that.
I have, my lord, the
You
documents.
have to take full responsibility for everything which is stated there.
Yes, my lord.
You cannot argue it as if it is done by the other side.
My lord, I have stated everything fairly
It
before
will be
this
a
court. my
very,
lord.
self-destruct kind of a thing.
Well, I have
He
stated-
can come and say that if it is collusive, then
No, my lord, that is not the case.
otherwise, how do you justify? It's not a one-day thing that I went there, I didn't know, I signed and I came back.
My lord,
You know how 13B is done.
yes, my lord.
So therefore,
She has signed the petition. She has appeared before the judge concerned, my lord.
She has signed, but then
She has
amounts to
deposed.
opening a forum which does not exist.
My lord,
And it can be done in every case.
My lord, I bow down to the what has fallen from my
Therefore,
lordship.
you cannot just, you will be
But
very
I have just
responsible.
placed the facts before the honorable court, my lord.
Yes.
I've just
We
placed
want him
the,
to be present. We want him to be present. The
yes,
nature
my lord.
of submissions that you are making. Behind his back, we will not allow it.
No, my lord, I have taken all possible steps to.
You may be required to ensure.
Huh? This one question.
That he has said that they are not responding to him. Serve afresh.
My lord, I will.
Is the address correct?
Yes, the address is correct. Delivered. It has been delivered, my lord. I have already the previous affidavit of service there on the call. 2 times it has been delivered upon me. Twice.
On the divorce, RC married again. RC married again on the divorce.
Let us see, where is the act? You have a copy of it?
My lord, I do not have a copy of that. There's no specific provision to appeal from an order under section
We want to
13B.
see where is the act? Come with that.
It is a Hindu Marriage Act, my lord.
Come tomorrow.
Lordship. তো বই এখানে ছিল না ভিতরে বার করেছে কি ফাইলের মধ্যে একটা ছিল তো ডাইরেক্ট
আচ্ছা এটা তো ইয়ে opposite party husband
Signature.
The highest it can go is collusion.
That.
Collusion.
Item 69.
For the appellant, I'm led by Mr. Shondipon Dotto, appearing virtually.
My lord, may I?
45 days.
Yes, my lord, 45 days.
You have sought condonation for 45 days delay.
My lord. Am I audible, my lord?
You have sought condonation for 45 days delay in filing the appeal.
My lord, I want to submit one thing, my lord. Actually, the arguing counsel for this matter, Mr. Dhruvanil Biswas, he just faced an accident today in the Calcutta High Court premises only. So he just directed me to appear and take a 1 week time, my lords.
That we
I
can do
don't
it, no
think-
problem. If he has met with an accident, that we will do, but we are asking you that the application for condonation is seeking delay of 45 days, whereas the office has reported 96 days.
My lord, the learned arguing counsel and the learned advocate on record might be knowing these details, my lord, because he
What
have.
details, sir, you
we
may,
have-
you
we
may
have
be
rushed.
required to file a supplementary to the application or something.
My lord, it was previously filed and that was, my lord, not pressed.
What
My
was
lord,
not-
the then advocate record has not pressed the application, my lord.
For
My lord, that
which application? There's only one application, buddy.
no,
Can one.
the same matter, my lord, it was previously filed. And my lord, that was also, my lord, not pressed by the then advocate, my lord. And it was not communicated with the, my lord, appellant.
Which application? What is
My
the
lord, the first appeal, my lord.
We are not on that. That will come later. The number of delays reported, you have to seek a condonation for those number of days. If the office has 100 days, you can't seek condonation for 50 days.
Yes, my
You have to seek condonation for 100 days. That's what we are saying. Then only it can be considered. For that, the learned advocate, even if he's not there, we can give you liberty to file a appropriate application or supplementary.
Yes, my lord, liberty may
Because the
be,
number of days don't tally with your application.
my lord, liberty may be given. my lord.
Yes.
Yes, sir, my lord, liberty might be given. That case, I am not even aware of this
The
details, my lord.
application filed for condonation seeks the condonation of approximate 45 days delay in filing the memorandum of appeal. Whereas the office has reported a delay of 96 days. Stop. Learned advocate
69
for the appellant. Mr. So-and-so submits that the learned advocate for the appellant has met with an accident and seeks an adjournment of the matter by 1 week, full stop.
My lord.
One week, after 1 week. Thursday, Friday, whatever.
Item number 70.
Question I have for the appellant lordship led by Mr. Kushal Chatterjee. Lordship, kindly fix this matter on Wednesday lordship. He will appear physically. He will appear physically to do
Good,
this
I am
matter.
for the respondent.
You have any problem with Wednesday?
Wednesday? No, I'm here, no problem.
Lordship, if possible to fix in a time lordship.
No, sir. Let him come, he will mention, if consent, then we'll see.
Grateful.
Day after.
Item number 71.
My lord, I am on behalf of the appellant. It is the CAN application section 5, my lord. The previous occasion, one direction to serve the office respondent, but I sent to the speed post,
Then what happened?
but not effective. Return.
And advocate submits that service is incomplete, stop. Use after 2 weeks. Stop. You can take appropriate steps in the meeting.
Grateful, ma'am.
The NCB.
72 হবে।
Item 72.
Let's call the next one.
73.
My lord, I am for the appeal. This is a matter, this appeal has been filed against the order of the Central Administrative Tribunal. The order dated 16/12/2025. Order is at page number 131.
Seventy-four.
The bill was confirmed.
Bail was confirmed, only bail was confirmed. Matter is pending still now. And as per rule 8 of the
What is the punishment, period of punishment?
period of punishment is
2 years.
2 years with 2 years and to pay fine of rupees 2 lakh. Only 2 lakh amount has been suspended for the time being, but the punishment has not been suspended. Only bail was granted. This is the position. Order is at page number 157. 157. CRA DB 2 of 24. Bail order. Error number 8. My only submission is let the appeal be admitted and stay. I have also paid for an order of stay. Stay may kindly be. Yes, yes, I have served on the last occasion. I have filed the affidavit of service. But on that day also they have not appeared. It was received. The track report is there, my lord. Track concerning. I prefer admission and for stay of the operation of order of the CAT.
It's not served.
My lord, track report is there.
From that we are saying it is not. It is delivered to Siliguri head office.
Yes, thereafter.
This man's address is in Ravindra Sarani police station, Bhakti Nagar. How it can?
But delivered, it is mentioned. Huh? Copy ne copy? Huh?
It's not served.
Brief, yes. No, no. Brief copy আছে? No, service copy nahi. একটু দেখে নিন জাস্ট এই তো আইটেম ডেলিভারি
Item delivered does not always mean to the addressee.
From Siliguri head of post office. Delivery office is Siliguri head.
That's not his address.
No, my lord,
His address.
his address is at Ravindra Sarani. It is within the head post office. Within head post office Siliguri. That is
See your memo of appeal, you have mentioned his head post office also.
Make a fresh.
Ravindra
Sarani, post office Ravindra Sarani.
Yes, that's not the Ravindra Sarani,
Yeah.
that is head office, Siliguri head office.
Delivery is through head. But destination is Ravindra Sarani. Destination is Ravindra Sarani, but it is through Siliguri head post office. And the last page it is mentioned item delivered.
Item delivered tracking report does not show delivery to the addressee. We will not accept it. You can take an information from the post office, give it to us. Because his valuable right is we are going to interfere with. He is getting a provisional pension. Right or wrong, that we will see, but when he is here,
Yes.
you either you take a report from the post office or you serve afresh, whatever you want.
Yes.
From the affidavit of service filed. The position as regards service of notice remains ambiguous. Therefore, allow the learned advocate for the writ petitioner a week's time.
Day after tomorrow.
Week's time for taking appropriate steps. By either obtaining an information from the postal department or effecting service afresh.
Yes. Good. Stick to the. Stick to the.
Item 74.
Wait, please.
You are saying?
I'm for the state, Malam, late by Mr. Siddharth.
I beg to appear for.
Lordship,
I'm for.
So the High Court administration was
Lordship.
supposed to file an affidavit.
I'm for the High Court administration.
What is the issue?
Milord, I am for the writ
पूरी जाएगी
petitioner.
हमारी।
Milord, the issue pertains, Milord, what is under challenge in the writ petition, Milord, is, Milord, two notifications. Wherein, Milord, the state has formed two police stations for the special task force and a subsequent notification by virtue of which, Milord, jurisdiction with regard to, Milord, all the cases which the STF will investigate, Milord, has been transferred and conferred upon two courts within whose territorial jurisdiction the police stations are being established, have been established. These two notifications, Milord, have been challenged. Milord, initially, this court considered the writ petition. An interim order was granted staying these two notifications. Subsequently, Milord, the state preferred an SLP. The Honorable Supreme Court, Milord, had stayed the interim order, directed this Honorable Court to hear and finally dispose of this writ petition in a final form. Milord, when this was taken up by the earlier coordinate bench, Milord, this Honorable Court from the opposition of the state found that so far as creation of these two courts are concerned, this Honorable Court in its administrative side has granted an concurrence to that. So on what circumstances and in what basis that concurrence was granted by this Honorable Court, the High Court administration was asked to be made a party in the writ petition and they were asked to file a affidavit disclosing, Milord, the circumstances under
They were
which.
supposed to file a report.
A report in the form of affidavit. Yes. So, Milord, I was only praying, Milord, if your lordships consider granting
You are giving it in.
Yes, Lordship.
Milord, 2 weeks time, Milord, to take out an exception to this.
You are for the.
I am for the writ petitioner.
Report in the form of affidavit is filed. Somebody is appearing virtually also.
Milord, Mr. Senior Advocate, Mr. Agarwal is representing the state.
Okay.
I beg to appear for the state of aspect.
The affidavit, the report in the form of affidavit filed is taken on record as paid by the learned advocate for the writ petitioner. 2 weeks is allowed for considering the same with a view to filing of an exception, comma, if required.
Grateful,
Let the same be done in the meantime.
grateful.
I am obliged.
বলেছে মানে নেই সিবি
Lordship, in item number 75, I'm praying for not today, Your Lordship.
76
What is it? Hearing matter? On the next.
77
For the appellants. If there's a direction to file paper books. The paper books are ready.
This is along with 76.
No. This is a separate matter, my lord, 77.
Oh, yes, sorry. Yes, yes. Wait.
And back over.
Have you served?
No, my lord, I couldn't serve because other side I couldn't get him. I've already informed him. He was supposed to be present today. The issue in the instant appeal involves. Mr. Kundu is there. my lord. Oh.
Give him a copy. Yeah.
The issue involved in this instant appeal is an order which was passed by the Honorable Single Bench. My lord, could find the impugned. My lord, the impugned order is at page number 13, my lord. 13 of the paper book. Begins at page number 13, my lord, the relevant part, my lord would get it at page number 15. Cost title starts at 30. The operative portion of the order, my lord, is at page number 16 and 17.
Yes.
But here there was an overdrawal in the pay of the petitioner. My lord, that overdrawal amount was deducted from the pensionary benefits. Subsequently, the petitioner claimed refund of the said overdrawal amount from the
Petitioners, it was not the petitioner's.
petitioner's wife.
Petitioner's husband's pension.
Husband's pension, yes. Husband was the employee. So the present petitioner claimed a refund of the said overdrawal amount. That is the petition which was filed before the Honorable Single Bench, wherein the Honorable Single Bench passed the impugned order. My lord, here the impugned order has been passed directing the Director of Pension Provident Fund and Group Insurance to release the said amount of 48,633 along with interest at the rate of 8% per annum in favor of the petitioner from the date of issuance of the pension payment order till the date of payment within a period of 8 weeks from the date of communication of this order.
What is the date of PPO?
My lord, the PPO, my lord, would find at page 11, my lord.
The date.
That is 20th July 2021.
2001.
2001.
So it was without any misrepresentation or suppression. Then was very clear. What was the post on which he was?
But he was a teacher, an assistant teacher.
issue may be of interest.
Yes. Unless the overall, he's an assistant teacher in a primary school.
Yes, that was a huge sum, 1993, 94.
Yes. My lord, there was a specific, there is a specific geo to this effect. And the persons who have continued beyond their period of superannuation, this is beyond the period of 60 years, as per their date of birth, they were given that option at that point of time to either forego their additional amount of salary that
He
they
has
have got.
continued beyond his,
He has continued beyond his 60 years. My lord, takes up the relevant geo. My lord, I have already.
so this payment which has been,
This is beyond. This is for the
that
addition.
period.
That period, for the additional period beyond the period of 60 years. After the date of superannuation.
The order, it doesn't appear. So did you file an opposition in the writ court?
No, my lord, opposition was not filed. It was an order passed on the said date from the there was no opposition filed.
How do we know that no opposition was filed?
But I was there in the writ petition. Opposition was not.
Why you did not bring this to the court? In the writ petition, did she say that this amount was paid to him when he was?
No, that was not.
Then if this fact was not there, then
It was suppressed by the petitioner.
were there?
It was suppressed by the petitioner.
You were there.
Number 2.
Take it up tomorrow morning.
Lakshmi.
The first case. Give him a call. You have got a copy.
Yes.
We'll see. Tomorrow first case. So we call that hospital.